I have that. Yes.
Oh, she was asking. So.
No. I was saying, why do I have this file? All right, Mr. Mendoza, if you come forward. And Adriana, would you tell Norma to come from the back, please? Thank you. All right. So counsel, have you received all of the discovery in this case?
I have not.
Has the state tendered an offer?
They have not been enough for me.
Okay. All right, thank you. All right, I'm going to reset this. And it's going to be reset for an acknowledgement of discovery to be given to me, plus the state to tender you an offer. All right, I need a 30-day reset.
Thank you, Your Honor.
You're welcome. Well, you got to get the reset and he has to sign the form. Okay. What date, Ms. Ferguson? All right, we're going to come back on June 12th. My pen has died. It's out of ink. Thank you. And you said June 12th? Here.
Can I do that like around 10:30?
Yes. And Norma, can you have the court reporter come? Oh, no problem. Okay. And who is the attorney for Zavala? It's Lorraine Efron. All right. All right, thank you. No, I told everybody 1:15. All right, thank you. And so we're going to take up the plea on Zavala.
Yes, ma'am.
Okay.
That's what I was worried about. I didn't know if they broke the file down there. All
Yeah.
Abraham told me was to come down here
Okay,
and get to the.
all right.
I think these are instructions.
Yeah.
But Sean, on Zavala, there's no application. Yeah, I don't know. Oh, no problem. Don't rush. It's good.
Are we taking some pleas?
Yes.
Are we good? Yeah.
Miss Efron,
Yes, Your Honor.
what's this? All right, Mrs. Zavala. Are you ready to proceed?
Yes, we're ready.
No.
Oh.
Yes. All right, court is calling 2023 CR 2620, State of Texas versus Julio Zavala. Now parties come down and announce for the record for the state
State.
defense.
Lorraine Efron for Mr. Zavala.
And are you Mr. Zavala? Counsel, have you received all of the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mrs. Zavala, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're gonna waive the repeater enhancement allegation. We're also gonna waive count 1 and proceed on count 2.
Any objection?
No, Your Honor.
Mrs. Zavala, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your
Did you understand the state is proceeding on count 2? The range of punishment for that offense is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Do you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Zavala, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone coerced you or forced you to enter into this plea? Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you were represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, state is proceeding on count 2 only. They're asking that your punishment be assessed at 4 years in the prison. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes.
State?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No.
Then to the offense in count 2, how do you plead? Guilty, not guilty, or no contest?
The contest.
State any evidence?
State offer state exhibit 1 in all attachments.
Objection.
I'm going to show you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state would be presenting evidence in the form of witnesses, statements, police reports, and laboratory reports, but most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, we're asking the court to respectfully follow the plea agreement. Yeah. Nothing further at this time.
All right, then the court will sentence you to 4 years in the prison and give you credit for any time served. Mr. Zavala, do you have a drug problem?
No, Your Honor.
Okay. Well, I was going to ask if he needed therapeutic community, but he doesn't have a drug problem. All right. Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it? And did you sign it?
Yes, Your Honor.
Yes, thank you. Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, state your excuse and we can go off the record. How old are you?
48.
All right, you're 48 years old. You're getting to the point in your life where you have more of your life behind you than in front of you.
Yeah.
Now, if you want to spend your life picking up drug cases, going in and out of prison, then that will be your life. You're going to wake up one day and you're going to find a majority of your life has been spent in custody.
Yes.
These 4 years that you've received, I would suggest to you that you sit down and actually think about where you want your life to be.
Yes.
And if you are doing things that are illegal to have things, at the end of the day, you know what's going to happen with things when we leave this world, whatever your beliefs are, those things going to end up with somebody else. And somebody else may not value those things that you so valued, and they'll probably end up throwing them in the trash or either selling them. They mean nothing to them. And you will have found that you spent all your life or a majority of it in jail over things. You understand? All right. Good luck to you.
Thank you, Your Honor.
Thank
You're welcome.
Judge.
And good luck to you on your deadlifting and everything that you're doing.
Thank you.
I'm going to be cheering you. Be sure to have somebody to film it so I can watch it. I watch it on video all the time.
Judge, are you
Yes.
gonna need CTV for anything else?
I don't think, let me see if you all have anything else on the docket. I think it's all family violence.
No whammies, no whammies, no whammies. Whammies, have you ever, it's the old TV show Press Your Luck?
Yes, I have. Oh, Norma, What did we do with Melvin Hernandez? We took care of that, correct?
That was a plea judge, I think.
All right, and then Francisco Luna, when has that been reset to? Okay, and then have him twice. Lindsay Pierce is done. Alfonso Diaz is done. Santon Wilson. What date are we bringing Santon Wilson back?
I'll make sure to write that down.
All right, and Norma, can you make sure that's in the court's file, July 13th? Oh, and Norma, did you, Albert Gunter, who said Larry Meadows was his attorney? Larry Gunter. I'm sorry, Albert Gunter. His SID number was 1012303. He was in the audience. Albert Gunter. Alexandria Alvarez. All right, can you look that up? His SID number is 1012303. And the other person who was here was Alexandria or either Alexander Alvarez. All right, that's it for you guys.
Thanks, Judge. You
All
guys-
right, let me see the file on Juan Antonio Garcia Sanchez.
You guys need-
Yeah, is it indicted? No. Okay. All right, Norma, we need a Spanish interpreter for Juan Antonio Garcia Sanchez. All right, I need to see all the files that are remaining, please. All right, the first person who's going to be up is Juan Antonio Garcia Sanchez, followed by, oh, Mr. Sanchez, we need an interpreter for you. I mean, that's what he has. He says Spanish interpreter needed. Does he not need an interpreter?
Yes, sir.
All right. All right, so we're calling an interpreter now. After that, it's going to be Jayden Green, then Brandon Sierra, Elsa Vaquera, Darren Doze, Stephen Stokes, Philip Diller, and then Manuel Rodriguez. So everyone, please remain seated. We're going to see what's happening with Mr. Juan Garcia Sanchez first. Thank you. You're welcome. Mr. Piddle, are you joining the states team?
What's that, Judge?
Are you joining the states team? Are you going to try this?
It's just an open seat. Take a lot of money for me to go back, Judge.
Okay, well, I mean, that's some negotiation you'll have to work out with.
That was short lived. Here's your seat.
All
I'll take Jason's.
Oh, so anyway, Deputy Laura, they canceled SWAT. And then I guess all of the fans were like, you can't cancel SWAT. So now they've uncanceled it. And now Call Me Cat has been canceled.
That was canceled, Call Me Cat.
Yeah.
That one was, I didn't like it. I watched it a few times.
Just for scheduling for my equipment, so the jury will remain for a little bit.
Yeah, the jury will be in at 1:45.
Okay, I need to run my courts.
Okay, sure.
Are we, do you have any more to use?
Oh, no, I don't. We're gonna be doing jury selection.
But I did look up, I don't think they were sectioned. Everything is defined.
Yeah, because we had a murder trial in the fall where a lot of it took place in these apartments. And all of the neighbors were still there because they were $100.
And it's
And
waiting
so
for-
it would be like passed down in the apartment. And she said she wasn't sure if it was gonna be his mom or whatever.
The departments still have their records. They should be able to tell us to be.
And Mr. Leal, if you want to take your seat and have your client take the seat at the desk. State, where are you all going to be sitting?
Over there.
Okay, all right, so if y'all want to move, so defense could have a seat. Okay.
No.
Sorry? No, I'm gonna be on. Yeah, we're gonna have full count.
Okay.
Mr. Liao? Are Mr. Liao, are you appointed?
Yes, ma'am.
All right. If you can have your co-counsel come up.
Afternoon, Your Honor.
Good afternoon. If you would like, because I realize getting people to sit with you, that's always difficult. You can turn in a voucher, but I'll only be able to submit it, or you'll be only able to submit it for the time you're in court, not for out of court hours.
Oh, okay, that's fine, thank you.
All right, you're welcome.
Yes, Your Honor, and I think I submitted a motion for second chair and all of that and co-counsel. So it's before the court, but it can be adjusted or however you want to rule it.
Yeah, I'll do it the way the court said. That's
All
fine.
right, Ms. Ferguson will put you in the system as second chair.
Thank you.
Thank you.
You're welcome. And then we're just waiting for the interpreter.
Oh, yeah.
All right, all the other attorneys who are remaining on the docket, if you can come forward. Who are you on the docket for?
Dose.
Okay. All right, so this is what's going to happen. I'm sure, as you all are aware, sometimes you think something's going to jury trial, then something happens and it doesn't go to jury trial. So we're picking on Mr. Liao's case, but if something happens, then one of you all going to be up next. So this is what I want you all to do. I want you all to report back here tomorrow at 9 a.m. And if you're here exactly at 9 a.m., because a jury will be on the only thing that's on our docket because it's Wednesday. So either at 9 a.m., you're going to get a reset date. So please be thinking of the dates that you may have vacation letters in so that Ms. Ferguson will know. So you all will come back at 9 a.m. tomorrow. Please be here exactly at 9 because I'll know if this is still going on or not. And if it's still going on, we'll give you your resets very quickly.
You want the
Yes.
clients present and I?
Yes. So 9 a.m. And I want your clients present so they'll know when their next jury trial is, if that's the case, and they sign off on it.
Okay.
All right, thank you all.
Judge, I have one thing.
Yes.
On my client, he'd had a violation in the past. You took him into custody, he bonded out.
Mhm.
And he has an ELM monitor and you set up the next setting, which is the setting that you would consider taking off the monitor or waiving. the fees.
If you bring him here tomorrow at 9 a.m., we'll take care of
The
that.
rest of them. Okay.
Yes.
Okay.
All right, thank you. So everyone, just make sure your clients know to come back at 9. And Mr. JUAN Sanchez Garcia, if you'll come take a seat.
I was going to apologize for my tardiness today.
No. I understand.
I am very sorry, and I'm actually working to get off cases because that judge has said if I'm not there, he will issue a short call.
Okay. All right. No, thank you so much.
I apologize.
No problem.
Yeah, no.
Good luck on your cases.
Thank you. I'm going to next.
Okay. All right. And if they have a question about where you were, they can call here.
Thank you, Your Honor.
All right. You're welcome. Yes. All right, state, how much time are you all asking for jury selection?
25 minutes.
All right, defense, how much time are you asking for?
Judge is asking me. How much time did you guys ask?
They asked for 45 minutes.
45? It's an hour. 2 days, yeah.
All right, and here's my next question. So in this case, the charge is aggravated sexual assault of a child, is that correct? And defense, if your client were found guilty, where is he proceeding to for punishment?
I'm sorry, what?
I said, if he were found guilty, where would he be going to for punishment?
I believe on the last time that I talked to my client, he wanted jury punishment.
All right, so if you'll do the application.
I believe I did of that already, but I don't mind doing it.
Oh, wait a minute. No, I have it and it says to a jury.
Right.
So he
That's
wants
what
to
it
go to
says.
the jury for punishment? Okay.
But we also need to put some money on the record concerning the plea, I mean, the offer and all of that, because I don't want there to be any misunderstandings. and
All right. So as soon as the court reporter sits down, you can put that on the record.
Yes, yes.
I am looking for that right now. There is not. Oh, I'm sorry. Yes, there is. There's a lot of, no, there's not. Yes, there is. And it was signed on March 20th. No, not right now. Thank you. No, I'm good. Thank you. Well, you know what? Actually, before you go, let me make sure I have the indictment on this case. I'm looking through the file for it. I'm looking. All right, if you could print out one for me. Thank you.
You're good?
We are good.
Okay.
All right. It's 2019 CR 6322. All right, thank you. Hi. Do you need a chair?
I do, but there's not a lot of room on that. I was thinking of that. You know, by the-
Oh.
Oh, okay.
Yes.
Okay, good. Thank you. I was gonna ask you.
We do have an extra. For sure, trial.
Yes.
Okay. We need a big one or a small one?
A small one is fine.
I'll give you.
Okay, all right, thank you. And could I see the charger from over there? Thank you. Hmm?
So why is it?
Okay.
We're gonna need more copies of small. You want to write a lot.
You're still.
Well,
working. Still working.
We need to be facing that direction.
Yeah. What do we do with that?
All right, court is calling. Hello. Aw. Aw. All right, court is calling 2019 CR 6322, State of Texas versus Juan Antonio Garcia Sanchez. Can I have parties announced for the record for the state? For the defense?
Rafael Leal and Brian Kimbrough for Juan Antonio Garcia Sanchez.
And are you Mr. Sanchez?
Yes.
All right, and we have an interpreter here. If you could raise your right hand. Do you solemnly swear affirm that you will faithfully translate from Spanish into English and from English into Spanish? So help you God?
I do, Your Honor.
All right, could you state your name for the record, please? All right, thank you. And my understanding is the defense, you wanted to put something on the record. Is that correct?
Correct, Your Honor.
All right, excuse me, could I be muted?
Okay.
Just a moment. Could you mute us, please? Ms. Cutter. Hi, since you're going out in the hallway, could you let Deputy Lord know we're ready for the jurors to come in? Thank you. Okay, no problem. Sure. Thank you, Norma. Yes. Yeah. No, and I always try to give it to my students early, so they don't have to worry about an exam. Thanks. I always teach college the way I would have wanted my professors to do it.
Start on the next. Let's see, yeah. Ma'am, go ahead and go to the top. Let's find your number up there. I'm sorry, 22 or 24. All right. 37.
All right, everyone, please be seated. And the person in the back, you're gonna have to take the hoodie off. Deputy Laura, is there a reason the person in the back has a hoodie on?
Ma'am.
Thank you. All right, everyone, good afternoon. Good afternoon, everyone. All right, everybody should be wide awake because you've had a chance, I think, to have lunch, hopefully. My name is Judge Stephanie Boyd. You're in the 187th District Court on the 4th floor. So what floor are we on? What court? And who's the judge? See, you guys just trailed off on that. So we're going to try it again. I'm Judge Stephanie Boyd. We're on the 4th floor in the 187th. So which floor? Which court? 187. Who's the judge? Stephanie Boyd. Oh, you guys are now in unison, like a choir. All right, and you're
Yeah.
probably asking, why am I telling you this?
They are.
The reason why I'm telling you this is because whenever we take a break, you all have to break together. When I say break together at this point in the process, that means when one person leaves this courtroom, everyone has to leave the courtroom. And if you get lost, which people have been known to do when they're not familiar with this building, you end up somewhere else other than where you're supposed to be. We've had jurors before where we're waiting for them because we can't begin unless you're all here. And then the deputy discovered them down the hallway trying to go on another jury. And then one juror looked up, he's like, I looked up and everybody was gone. So the reason why I have you say those, because one, if you only know fourth floor, hopefully you'll walk in, peep in, and you'll be like, that was the judge. Or either if you say the 187th, there's only one 187th, not only in this courthouse, but in all of Texas. There is only one Judge Boyd in this entire courthouse. So if you remember any of those things, you are never lost because you can always ask someone and they will know. To my left, I have the court reporter. Could you raise your hand for them, please? She's extremely important. And I'm a firm believer that we should all try to make people's jobs as easy as possible if we can. So she is taking down everything that everybody is saying. And people may say, well, that's easy to do. Actually, it's not. And let me just tell you why it's not easy to do. Because everybody speaks at a different pace. Sometimes people have accents and you got to get used to their accents. Then you have the whisperer. And that makes it difficult for her. So all of you have cards in your possessions. Could everyone please raise those most important cards that you have? All right. So, nope, keep them up. I'm going to see if you all are able to do this. So far, no jury has been able to follow this instructions, or I should say these two instructions. Everyone in this box, put your numbers down. Everyone on this front row, put your numbers down. Just on the front row, everybody else keep your numbers up. All of the people who have their numbers up, whenever you talk, I'm going to ask that you stand if you can, because that will make it easier for the court reporter to hear. So if you are holding your number up, that means whenever you speak, you need to stand. Otherwise, the court reporter will not be able to hear. Does everyone understand? All right. No jury has ever been able to follow that instruction, but I have faith that you all will be able to do it. So if you can lower your cards, and sir, I'm gonna have to ask you to take the cap off. Now I'm going to have the parties introduce themselves for the state of Texas.
Good afternoon. My name is Brittany Mitchell. Sitting with me is Travis Banks.
All right, speak loudly.
This is Travis Banks and Ruben Herrera.
All right. And for the defense?
Good afternoon. My name is Rafael Leal, and by me is co-counsel Brian Kimbrough, and we're representing Juan Antonio Garcia Sanchez in this matter, in this case.
All right, everyone may be seated. Now, all of you have had a chance to view the parties involved in this case. Is there anyone here who recognizes any of those parties? If you do, please raise your card. Okay. Now, the other thing I want to talk to you about is languages. I love languages. I think they're beautiful. Everyone, not everyone, but a majority of the people in the colleges that I went to, they all spoke different languages. In middle school, we called it junior high back in my day. So I know some people say middle school now. In middle school, I had a choice of a language to take. I'm originally from Louisiana, so I guess you can figure out which language I decided to take because I had dreams of where I would be living. So I ended up taking French. My friend Tanya said, Stephanie, you should take Spanish. I said, no, I'm taking French. I know where my life is headed. And lo and behold, I probably should have taken Spanish, but I didn't. And I ended up in Texas, which is a long story, but school brought me to Texas. So there are people in my law school here in Texas that could speak 6 languages. They try to teach me. I can probably say hurry up in every language. That's what they taught me. So I say that to say that sometimes people are in the United States and they do not speak the English language, or they do not speak it so comfortably that they feel okay with having speaking English for important matters. Does everyone understand? And I know plenty of people who just decide, you know, this is extremely important. I want to make sure that I understand absolutely everything that's being said. And the best way for me to do that is in my native language. Whenever I go to Paris, which before COVID, I would go every year, some people would say, I don't like the French because they're upset with me. And I tell them, well, are you even trying to speak the language? And they would say no. Lo and behold, in the United States, for some reason, everybody thinks that there is a national language here. There is not. English is not the national language for the United States. I know people think it is, but it is not. And there's no law that says it is. That's why you have a lot of people speaking a different language. So, Mr. Juan Antonio Garcia Sanchez is using an interpreter here today, and that interpreter is interpreting what everybody says in English to him in Spanish. And if there's something that he wishes to say, he's going to speak to her in Spanish and she's going to give it back to us in English. Does everyone understand? Is there anyone here who's going to hold it against him because he is using an interpreter here today? Now, the charge in this case is aggravated sexual assault of a child. Now, I know sometimes when people come down to court, they're like, I would love to come down and take care of a case where maybe there was a car accident. This is the criminal courthouse building next door with the green rooftop, which they call the historic courthouse. That courthouse handles civil cases. Here, we handle all manner of criminal cases, and this is a felony court. And I'm going to speak to you about that charge in a little bit. But when the state and the defense speak to you, they're going to be speaking to you about hypotheticals. Remember that and hold on to that, because neither the state nor the defense can talk to you about what they think the facts are in this case. Does everyone understand? The only way you would know what they think the facts are is if you are sitting on the jury and you're hearing testimony. So whenever they talk to you, it is hypotheticals. Now, I want to talk to you about an indictment. An indictment is a means by which someone who's accused of a felony is brought to court. You are not to consider an indictment as any evidence whatsoever. For example, how many people here have had a traffic ticket? I'm going to have you practice raising your cards. Don't be shy if you've had a traffic ticket. Okay. There are some who have not. Wow. All right. So I've had a traffic ticket before, many years ago. I want to say it was about a year ago and I was only 21. So now I'm 22. Okay, there should not be that much laughter. You should be saying like, wow, she's so young. But whenever you get a traffic ticket, this is what I've discovered in San Antonio. It happens probably in every city. Nobody knows what the yield sign means. Sometimes people disregard school zones. So when I first got my traffic ticket, at that time they were giving out little paper, and the officer would write on a piece of paper and take it off and give you the ticket. Now I think it's all computerized or something. But when you accept that ticket, you're not saying, hey, I ran a red light or I rolled through a stop sign or I didn't yield properly. That ticket is telling you, this is what I'm saying you did. This is where you need to be. It's telling you what you're charged with and where you need to be to answer to this. And by you accepting that or appearing, you're not saying you're guilty. Does everyone understand? So an indictment is not evidence of anything, and you cannot consider it as evidence of guilt against the accused who's here today. Does everyone understand?
Yes.
Is there anyone here who cannot follow that? All right, the next thing I want to talk to you is certain constitutional rights everyone has. So how many people have seen Beretta? Thank you. Thanks for owning your age. The young people have no idea what good series are. So you know, in my day, there was Beretta, Mannix, Barnaby Jones, Paper Chase. Now I think they have The Practice. So I'm sure everybody here has seen a legal show before. So in the legal shows, they talk about people's right to remain silent. Has anyone not heard of the right to remain silent? And don't be shy if you haven't heard of it. There's no harm in that, but just let us know. So anyway, the right to remain silent means several things. One, it means that in a criminal case, someone who's accused of a crime does not have to testify against themselves. They don't have to come on the witness stand and testify. The state cannot call them to testify. There are many reasons why people may not want to testify. I've been a defense attorney. I've been a prosecutor. Sometimes maybe the defense attorney tells their client, state didn't prove their case. There's no need for you to testify. Sometimes it's, I'm afraid I'm not going to understand all the legalese. Maybe I don't want to testify. Sometimes it's, I'm afraid of public speaking. I stutter. There are a host of reasons why someone may choose not to testify. But here's the question. According to, well, here's a statement and then a question. According to our constitutional rules, you cannot hold that against a person if they decide not to testify. You can't be like Mrs. Kravitz and Bewitched saying, well, I wonder what they would have said. And I think maybe they would have said this. So I'm going to bring that into my deliberations. If you are selected for this jury, and if Mr. Sanchez decides not to testify, you cannot consider that whatsoever. You cannot hold it against him. You cannot be thinking about it. Well, I wonder what he would have said. You cannot be saying, well, I would say something if I were accused. Because honestly, when people say that, you really don't know unless you've been accused. Everybody always has an idea of what they would do in certain situations. But then when the situation happens, you're like, wow, this is completely different than what I expected. So is there anyone who will consider it or hold it against Mr. Sanchez if he chooses not to testify? Okay. All right. The next thing I want to talk to you is about the burden of proof. And there are two things that go with the burden of proof. One is a concept called everyone is presumed to be innocent. All right. Everyone is presumed to be innocent until and unless the state presents evidence beyond a reasonable doubt to each element someone is accused of that they have committed the offense. So at this point in time, if you had to vote on whether or not Mr. Sanchez were guilty or not guilty, what should it be? Yeah. And the reason being because you have not received any evidence whatsoever. All right. So what is proof beyond a reasonable doubt? Because that's the burden in criminal cases. When I went to law school, there was a definition for proof beyond a reasonable doubt. I learned it forwards and backwards. If you didn't know it, I don't care if you made an A+ in your criminal class, you felt like a failure. I knew it forwards and backwards. My first trial as a defense attorney, I said it. I was so proud of myself that I didn't stumble on any words. I got the commas just where they were supposed to be. I did the pause where it was supposed to be. And after that trial, guess what? There's no longer a definition for proof beyond a reasonable doubt. Do I still know that definition? Yes. But there is no definition for proof beyond a reasonable doubt. So when I was a defense attorney, when I was a prosecutor, I would tell people what proof beyond a reasonable doubt is not. So no one, if they were deliberating on a case, would get confused. For example, next door in civil matters, car accident, they have what's called preponderance of the evidence. That's really more likely than not that something occurred, or more likely than not that somebody's responsible for something. That burden is lower than proof beyond a reasonable doubt. So if you find yourself deliberating and you're saying, well, more likely than not, you know that that is not the burden. The other burden they have on the civil side is called clear and convincing evidence. Clear and convincing evidence is what is needed to terminate your parental rights. Someone saying, we can't trust you with your children, you will no longer be their legal parent. There's a burden that's higher than that. And that burden is proof beyond a reasonable doubt. That is the highest burden we have here. Does everyone understand? And no one can give you a definition of it because there is no definition. Now, there are two phases to a jury trial. First phase, people like to call it the innocence phase, but that's not what the first phase is. The first phase really is whether someone is guilty or not guilty. It's not whether someone is innocent or not innocent. It's whether the state proved their case or did not prove their case. So that's the first phase. If someone is found not guilty, there is no phase two, because phase two is what's called the punishment phase. In criminal law, it's required that the defendant or someone who is accused of a criminal case make an election or make a determination of if they were to be found guilty, who would they request to give punishment to? They can make a decision that they will come to the court for punishment if they were found guilty, or they will come to the jury if they were found guilty. Does everyone understand? The election of punishment in no way means that someone is guilty of an offense, and you should not consider it as such. Is there anyone who can't do that? All right. It is just the law that says a person must make a decision that if they were found guilty, who would they go to punishment for? In this case, Mr. Sanchez has decided that if he were to be found guilty, he would ask that the jury assess his punishment. Does everyone understand? Yes. Now, this offense, the range of punishment is anywhere from 5 to 99 years or life in prison. Now, that is a wide range, is it not? You got 5, 6, 7, 8, 9, 10, 9, all the way from 99. You can count from 5 years all the way 99 and then life. That's the range of punishment for this offense. Now, here's the question about that. That's the range. That is what must be considered if someone were found guilty. Does everyone understand? Yes. Now, people get confused because usually what attorneys will ask you is, can you consider 5 years for aggravated sexual assault of a child? Can you consider 6 years? And then people will usually raise their hand. No, I can't consider it. There's a difference between considering and giving. Now, I told you that in this case, the state and the defense cannot give you what they think the facts are. They can only speak in hypotheticals. So I told you what the range of punishment is for this offense. It's not whether you would give somebody a specific amount of time. It's whether or not you would consider it. And the reason why the ranges of punishment is so wide is because maybe there's an instance where you're like, I would consider giving somebody 5 for this, or I would consider giving someone 10 years for this, or life for this. I remember when I would practice, sometimes people would talk about charges and they would say, well, maybe you would look at somebody's childhood and say, I didn't know this about their childhood. Now that I know this about their childhood, then maybe I will give them 6 years. But you don't know anything about a case. So the question is whether or not everyone could consider the full range of punishment and keep an open mind. If you were to find somebody guilty, keep an open mind about punishment. Is there anyone who cannot do that? And keeping an open mind about punishment, if that were the case, that would mean have an open mind, listen to whatever evidence is presented, if any evidence is presented with regards to punishment. Is there anyone here who cannot do that? All right. The next thing I want to talk to you is what's called the one witness rule. And when I talk to you about this, I'm going to give you a hypothetical. Do not add anything to my hypothetical. If it's not a dark and stormy night and vision is blurry, don't add that. So, first question. If someone were in a dark alley They got lost. Let's just say they go down a dark alley and someone comes up to them and steals their purse. And they call the police and say, this person stole my purse. I can identify the person who stole my purse. If you give me a lineup, I'll be able to tell you who it is. Police give them a lineup and they say, this is the person who stole my purse. And there are only two people in that alley, the person who stole the purse and the person whose purse got stolen. Is there anyone here who thinks that the police or the state just say, well, I'm sorry, it's just your word against their word, so we're not going to do anything? Is there anyone who feels that way? So this is the one witness rule. If someone comes to testify and that person is credible, which means you believe what they're saying, I will swear them in to tell the truth. And they say, yes, I will tell the truth. They testify and they prove each one of the state's elements. Everyone. There is no question about their vision, because if you start questioning their vision, that means that you maybe are questioning their credibility. There's no question about, well, maybe they did this, or maybe. If you put maybe in it, then that means that you're adding things to my hypothetical. So it's one person who comes to testify. You believe them. They prove every element of the state's case. Is there anyone here who would say, yeah, they proved everything, but I still need more? Okay. Now, the next thing I want to talk to you about, is there anyone here whose English is not your first language? If it is, raise your card. All right. I can't believe there's only one person whose English is not their first language. All right. Number 67. I think people need you to answer so that they'll feel like it's free for them to answer and nothing bad will happen. All right. Number 67. What is your language?
Spanish.
Spanish. All right. How long have you been here in the United States? All right. Have you been able to understand everything? Okay, awesome. And how do you say hurry up in English? I'm sorry, in Spanish. I'm sorry?
What is it?
Yeah, but there are two ways, because see, I had another juror in here and they said there are two different ways. So there, you only have that one way. Okay. Okay, awesome. All right. So everyone sees nothing bad happened to him. Is there anyone else whose English is not your first language? See, 43. And let's see if the rules that I put in place at the very beginning will work. Nobody say anything. 43.
First language is Spanish.
All right. And you followed the rule, you stood. All right. So you heard juror number 67 tell me how to say hurry up in Spanish. Do you agree with that? Okay. All right. Thank you. All right. Anyone have any travel arrangements that are coming up, non-refundable tickets can't be placed in my name, or you have some sort of issue, time constraint? If there is, please raise your card. And once I call your number, please lower your card. 3, 4, 10, 16, 17, 28, 45, 51, 55, 66, 68, 74, and 75. Number 3, what is your time constraint?
So from the 23rd, the 27th, work.
Oh, June 23rd?
No, of this month.
May 23rd.
Yeah, May.
All right, that's not going to be an issue.
Okay.
All right, number 4.
I work in Odessa, so only here 1 week out of the whole month.
All right, and that is this week?
Yeah, I'm off actually this week.
Okay. And I bet you're like, "Ah, I got to do jury trial. I can't even enjoy myself." So when did you go back?
On Tuesday.
Okay. Number 10.
Getting married July 14th, so I didn't know if that was gonna be within.
All right. So are you trying to use this as a way to get out of that? Are you excited? All right. Well, congratulations. Where is it being held?
Fort Worth, Texas.
Okay, all right, awesome, thank you. Everyone, number 10 is getting married. And all the other people who are married can start giving him advice. All right, number 16.
Family vacations.
Uh,
Grandchildren,
Okay, and when are you going?
next week, I think, through next, Saturday.
All right, so let me see. Just one moment. Is that Monday, the 15th?
Yes, ma'am.
All right, and where are you headed?
We're going to Port Aransas,
Oh, wow. What are you guys planning on doing in Port Aransas?
barbecuing, family stuff, and have the grandkids. I have 14 grandchildren.
Oh, my gosh. Your hands are going to be full.
Oh, yes.
Well, here's what all the children want to know. Why do you let your grandchildren do everything and they don't have any rules, but your children have rules? That's what they always want to know.
You know what's funny? Kids want me to put rules on my grandchildren. I said, that's my job.
I like it. Thank you so much. As long as I've been here since 97, I've never been to Port Aransas, so that's on my to-do list.
Beautiful. man.
Okay. All right, I'm going to make it happen. Number 17.
I have work events in South Texas, starting tomorrow.
All right, what work do you do?
Rehab medical cells. So power and manual wheelchairs for veterans and people with disabilities.
All right, thank you. Number 28.
May 23rd through May 30th. Flying to New York for a week,
Oh, what are you going to be doing in New York for just a week?
visiting my daughter.
Oh, okay. Yeah, I don't think this will go to the 23rd, but thank you for letting me know. Number 45.
I'm actually in the Army Reserves and we do have drill next Thursday all the way to Sunday. We'll be in Fort Hood for our final range. And I'm gonna be in the First Response Academy on May 22nd, which is the day after my last trip.
All right, and I know how they are about that. So that's the 18th.
Yeah,
It's when so when do you actually have to leave? Because you say it's on the 18th, will you be leaving on the 17th?
that has not been established yet. More than likely, we're gonna leave early morning on the 18th.
Okay. All right, thank you. Number 51.
Europe starting Tuesday next week.
And where are you headed in Europe? Oh, I love Italy. What parts? Oh, wow. Everybody here is getting sort of jealous. And I can tell they're like, make her stay.
Yeah.
Well, safe travels. I would tell you, if you get a chance, stop in Florence and go to the leather market and bring cash. Yeah, somebody's like, yes. Number 55.
My mother, she's actually.
Oh.
She's going into rehabilitation tomorrow, and so I help with, I'm not her main caregiver, but I help she's 76, my father's 77. So I help with all the coordinating.
Okay. All right. Thank you for letting me know. Number 66.
May 26th to June 3rd.
Oh, what are you doing in California?
Taking my kids to Disneyland.
Oh, wow. I've never been.
Yeah, we're going to several places, but if it's far enough away.
All right. Oh, yes. So what date? I'm sorry.
May 26th. Till June 3rd.
All right. I think you shall be okay. And I think you're going to need a vacation when you come back. Number 68.
My mother has lung cancer. And
Oh,
tomorrow we have an appointment with an oncologist.
okay. All right. Well, we're going to send our prayers and everything is going to go fine. Number 74.
I just started a new job. I can only miss 2 days of training and then I have to, if I'm here for too long, I have to stop for a month without pay and restart.
And when is this training?
Today's day 2 of a 6-week. 6 week date. Like the first 3 weeks were how to adjudicate claims, and then the second week is actually taking actual claims into consideration and processing claims.
All right, number 75.
Work on Thursday, but unfortunately,
I'm sorry, I can hear you trail off a little bit.
my cousin lost his wife. We have a few more Thursdays.
All right, I'm sorry to hear that. Thank you for letting us know. Anyone else?
A quick alibi, ma'am.
Yes.
I'm an Army physician assistant. I'm mission essential personnel. We have a trade-off training inspection this week.
Mhm.
Not sure of the report, but
Oh, no, thanks for telling me. When will that be? What day?
it's this week, so it was Monday through probably Friday.
All right, do they have you on a pager or something?
They don't.
Oh my gosh, do they even know where you are right now?
Some do.
All right, is there anyone else? 67.
We started on the June, this is my birthday, or like making around the area.
All right, you going where in June?
Maine, just Maine and Rhode Island, all the northeast.
Oh, wow. Well, thank you for letting me know. I don't think we're going to be here till June. See, this is what happens. People start telling me their travel plans, and then everybody's like, oh, it's okay for me to speak now. All right, 23.
Moving in June,
Oh, where are you moving to?
Eagle Lake
Eagle Lake.
by Houston.
Ah, okay. All right. Thanks for letting us know. 33. Are you going with this gentleman or no? Okay. All right. Thank you. And there was someone else? 24, yes.
Yes, where I work, I'm using my vacation time. They don't give me no time off for this.
Oh, I can tell you they can't fire you for this.
Okay,
All right.
thank you.
All right. Thank you so much. 32.
My mom has a really early appointment.
All right. I don't think we're going to be here till May 30th. Thank you. 61.
Family vacation is June 2nd, since we're getting into it, we're not likely to be there, but 2 quarter rounds.
Ah, are you going with the person over here? You guys should do a road trip together. I'm not from Texas, so I'm always like, hey, let's fly. They're like, Stephanie, you can drive. Come on. Like Galveston. I'm like, let's fly. They're like, Stephanie, no. All right. Anyone else? All right. So now that you've had a chance to see some of your fellow jurors, other than meeting in the central jury room and standing out in the hallway and being called back, do you know any of each other than just meeting for the first time today? All right, that is so odd. Usually we have students and teachers or co-workers. One time we had the ex-wife and the current wife. So they got along great. Everybody was happy with their status. All right. So one thing I want to let you know, I am the alternate presiding judge this week. So you may end up seeing people coming through this door. And when they're coming through the door giving me paper, it has absolutely nothing to do with this case. So sometimes I get officers coming in. The people who you see coming in through that door who look shocked is because they didn't read the sign on the door that says jury trial in session, don't come in through this door. And I think we also have one out in the hallway. So just know that when those things happen, it has absolutely nothing to do with this case. So please ignore it. The other thing I want to talk to you about is breaks. If ever you need a break, maybe someone needs to go to the restroom or whatever, just do the hand signal for a break. I will either see it or one of the attorneys or the deputy will see it and we will give you a break. But once one person goes for a break, everybody needs to leave. And when you leave for a break, if you want to leave your personal items here, you can leave them here. Nobody's going to touch those items. All right. So I'm going to tell you 2 stories. And they are both true stories. The United States government, our government, when you think about it, they really don't ask a lot of us. The only thing they ask you to do is pay your taxes and show up for jury duty. That's it. They don't even, I don't know why people don't, but they don't even ask you to vote. You don't even have to vote if you don't want to. And my uncle lived in a small town called Grand Cane, Louisiana. And in its heyday, it still didn't have a lot of people. And so all his teachers would skip him in school because he was super intelligent. My mom, one of his sisters, and his other sisters and his other brother was like, man, why you got to be so smart? Because when they would go to school, everybody knew them. Everybody knew, all the teachers knew who was related to whom. And so they would get in school and everybody would say, your brother's super smart. We're not going to expect any less of you. So once he graduated from school, the Vietnam War broke out. And he told my grandmother, I'm not going to wait for the draft because everybody, all the boys in Grand Cane was being drafted. And he said, I'm just going to go ahead and sign up. And because he had been skipped in school, he was underage. And so my grandmother had to sign for him. And I tell this story because that's a sacrifice. Jury duty is an inconvenience. You got to pay for parking. There's a lot of one-ways downtown. But if you can imagine my grandmother, this is her firstborn son, and she's signing for him to go fight in a war. He had never been out of Louisiana, never out of small Grand Cane, sending him overseas to a country that I guarantee you at that time, a majority of Americans had never really heard of. But she signed for him to go and send him. And the reason why I bring that up, because your country, our country, doesn't even have a draft anymore. If you don't want to go to war, unless the rules change and the law change, you don't have to. If you don't want to be a reservist, you don't have to. If you don't want to join the military, you don't have to. So there's not a lot that's being asked of you. That was a lot that was being asked of my grandmother. He's since passed. He did make it back from Vietnam, of course, a different person than the young, innocent person who was sent to Vietnam in the first place. But to me, that's a sacrifice. Jury duty for some people is an inconvenience, but we need jurors in order to have a jury trial. And even though you will hear defense attorneys make jokes sometimes, state, even myself, it's because that's just what we do, right? Because we want people to talk so that they'll know who can be fair and sit on a jury. The other thing I want to talk to you about is one of my friends from law school. I always knew I wanted to practice criminal law. I never wanted to do civil, even though I've done civil. That really wasn't my passion. Criminal law was. So my friend, I hadn't seen her in a long time since we graduated from law school because she's doing civil work. I'm doing criminal work. And on the criminal side, usually you're in court every day. And you're usually in trial about every 3 weeks or so. So she calls me up and she says, Stephanie, I got called for jury duty. Yay. I said, well, let's do lunch. She's like, yeah, we can do lunch. So at the lunch break, we go have lunch. I asked her how things going with jury duty. She's like, fabulous. And now since I'm a judge, I think to myself, how can it be fabulous? You're not in the 187th with Stephanie Boyd. And so she says, I'm not going to get selected. And I'm like, what do you mean? Because I'm like, what's the key? What do you mean you're not getting selected? And she said, it's like when we're in law school. She's like, I'm in the back with my head down and I'm keeping quiet. And so I started laughing at her. And she's like, what's so funny? I said, you're so getting selected on that jury. So I wait for her at 5 o'clock. I said, hey, how's it going? She's like, we're going to be having lunch all week. I'm like, yay. So I tell you that to say that there are no right or wrong answers, but the attorneys are trying to get to know you in the limited amount of time that they have to get to know you so they can have someone on the jury who's going to be able to listen to the evidence and base their decision on whether a person is guilty or not guilty, just solely based on the evidence that they hear. Now, at the beginning of this, I told you what the charge was, aggravated sexual assault of a child. And I know sometimes different things have touched people's lives. Like sometimes people are like, well, I was just in a car accident today. I can't hear a case involving a car accident. But the key in criminal cases is whether or not, even though you may have had an experience, whether or not you can put that aside and listen to the evidence that's being presented to you. Evaluate the witnesses, just make a determination yourself whether you think they're telling the truth or not telling the truth, and then making a decision on whether someone's guilty or not guilty solely on what is happening inside the courtroom. So that means not based upon what your past experience were with your life or what has happened to you, but just from witnesses that are called to testify. Is there anyone here who cannot do that? All right. And I'm sorry, I think your number's upside down. Are you number 9, 29, 36, 58, 51, 7, 3, and 67? All right. And 41. All right, so I'm going to turn it over to the state, but before I turn it over to the state, I want to let everyone here know that each party has 45 minutes. And I really don't like to break up the rhythm that attorneys have going. So does anyone need a break? All right, so this is what we're going to do. We're going to take a break, and when we take a break, that means everyone has to leave. You can leave your personal items here. If you're going to take a restroom break, as you can see, there are a lot of people in this courtroom. If you follow where the stairwell is, you can go on either floor. On either side of the stairwell is a restroom. They have the females on one side, the males on the other side, and you can go upstairs or downstairs. Even if you go all the way to the basement, if you find the stairwell, that's where the restrooms are. Does everyone understand? So what I'm going to do is I'm going to ask everybody to come back at 3 p.m. Here's the thing about that. When you come back, line up outside. Do not come inside the courtroom. The deputy will bring you in. Before I release you, people just like rushing. Before I release you, look to your left. Look to your right. You are responsible for the person who's next to you. That's your buddy. So make sure that the person who's supposed to be behind you in line is behind you, and the person who's supposed to be in front of you is in front of you. All right, so if everyone line up side at 3. All right, everyone, please rise for the jurors.
There we go.
Okay,
Any objections?
No good.
no objection.
Defense. Say.
Yeah.
Defense.
Yeah.
He and I conversed with each other and I just know she's here and.
Then we gotta go through.
Okay, all right, we'll check that out. Thank you. All right, everyone, please find your seats and have seats.
Just making sure.
I'm like, what are you doing?
I know, I thought there was still one, but the guy.
Which I snuck past you.
He did.
Oh, there was one. Sorry.
I knew there was one, I was like, okay. All good. Taking it home.
I wonder how much you would do.
I have interviews today. I'm like, I'm not gonna cancel them yet. I was just sending them a heads up.
We're missing one. 48, Joel.
The other jury. You're the last one.
So that means that somebody was not a good buddy today. I think that second row over there is going to be trouble. All right, so we'll start up as soon as that juror is back.
Miss Rowe, what is the number of the juror that's missing?
48.
48?
All the bread is for Your Honor.
Thank you.
All right, so I believe there was a juror who said that she knows someone. Which juror is that?
Oh, sorry.
What's your number?
13.
13 and 36. All right, juror number 13. How do you know juror number 36?
I'm an X-ray tech and she's the radiologist that we work with. And we just ran into each other in the hall.
And you're like, oh, you're on this jury. I'm on this jury too.
Exactly.
All right. All right. With that being said, what I'm going to do is oh, you may have a seat.
Thank you.
And juror number 36, you know juror number 13, correct?
Yes.
Okay. You didn't stand. You ruined the perfect record.
Still, you have a big booming voice. I'm not used to.
Okay.
So tall.
All right, I'm going to excuse her for not standing at that time. So we're going to start back over. So everyone remember who should stand. Don't fail me. I still have faith in you. And there are 2 jurors who have serious medical issues with family members. Normally, I don't excuse jurors this early. I did excuse a juror once before when their dog was receiving surgery and they needed to know whether or not to go forward with the surgery and whether or not they would determine whether the dog was going to live or not. So there are some times when there are other things that happen that we have no control over. So as I said, normally I don't do this, but I think it's very important for juror number 55. I understand that sometimes you have issues with parents and you need to be there. And even though she's saying she's not the full caretaker for her mom, I think everyone here who has parents know, you really want to be there to make sure everybody's doing everything that they're supposed to do. So there's been no objection by the defense or the state to letting juror number 55 leave. So I hope everyone understands the reason why I'm allowing juror number 55 to leave. All right. You're welcome. But leave the expensive numbered card behind. All right. And I hope everything goes well with your mother. The other person we have is juror number 68. And juror number 68 has told me that his mother is dealing with lung cancer. I think that's important, and I'm sure he needs to be with her. So I hope everybody understands why I'm letting him leave as well. And both the state and the defense said that they did not have any objection to his leaving. I didn't tell that juror who's leaving, but make sure that you go downstairs and get your parking validated. Okay, that's awesome. All right, so if you'll leave the number behind and the deputy will give you your pass. All right, now with that being said, we're going to proceed with the state. State, you may proceed.
All right. Thank you, Your Honor.
You're welcome.
Good afternoon. I am Brittany Mitchell. I know it was a brief introduction. Travis and Ruben are my partners. We are in the family violence unit. We handle family violence, assaults between family members, people in the household, and also sexual crimes, and especially crimes against children. Today we're here for Juan Garcia Sanchez. Oh, it's not on. I put this picture of Law and Order there. Anyone here watch Law and Order? Anyone who doesn't know what Law and Order is? The show. We're not Law and Order. We don't, things take time. We don't look as polished, scripted, and in actuality, this is kind of more along the lines of what our everyday looks like. I put this out here because you will see us on our phones, you will see us on our laptops. It is not because these cases aren't important. It's because we are coordinating multiple cases at a time. We had about 11 cases that were set for trial today, and we had to be ready on all of them. So we are constantly coordinating. Jury selection. We know you have strong opinions. Who here knows what this picture is? What it's from? Hold your number. Juror number 10.
12 Angry Men.
12 Angry Men. Juror number 32. I'm sorry, what was your number? 23.
You got to stand up.
Oh, right. 23.
And juror number 32, can you stand up?
Yes, the movie,
Okay, do you know what that movie's about?
it was a trial based on circumstances as well. I don't-
Okay, juror number 27, you look like you really want to talk about it.
Yeah, because it was from a stabbing. They were trying to confirm the boy, and it was like with a comb. It was like the switchblade. Right. Yeah.
Okay, and what are they doing in this picture?
Trying to remember the scene because that's when they're all trying to figure out if he's guilty or not, and they have one guy who's saying he's always not guilty, and then all the rest are blaming guilty, so they have to stay in the courtroom.
So, this is the jury, right?
Or, yeah.
12 angry men, 12 jurors, back when it was men. Obviously, it's a little different now. Oh no, what just happened? Oh. Okay, well. Okay. Above all, tell the truth. This is the only opportunity where you can have kind of a dialogue with us, ask questions. Obviously, we can't get into the case itself, but this is how we get to know you and get to know if y'all would be good on the jury or not. The splash zone. Anyone here who does not know what the splash zone at SeaWorld is? Okay. Juror number 43. Would anyone like to tell juror number 43?
It's basically the zone where they're telling you that you have a possibility of getting wet if you sit there.
Yes, yes. So you go to SeaWorld and there's like a bunch of benches and the ones at the top are white or whatever. And then there's this lower section, they have like dark blue colors. And that's like a warning, like, hey, if you're in this section, you're likely to get wet. So the splash zone in jury selection would be probably the first 30 of y'all. Because y'all are the ones that are the most likely to get on the jury, especially if I don't hear anything from y'all. So no offense to y'all, but I probably will be directing a lot of my questions this way. So that all that being said, you need to speak up. I think a lot of you will. I saw a lot of managers and supervisors and stuff in y'all's jury cards, so I feel good about it. And then I put this quote. This is a quote from the Office of Court Administration. Jury service is a privilege that offers the average citizen an unequaled opportunity to influence and deliberate over fundamental matters of justice. As a juror, you are in a position of responsibility. You will need to be fair, impartial, and be willing to make decisions that are not based on your personal feelings and biases. Speaking of fair and impartial, juror number 7, you were laughing as soon as I showed that picture. Who's in the picture? Cheech and Chong. And anyone know what they're kind of known for? Marijuana. Juror number 63. Marketing. Yeah, they like to smoke a lot of marijuana. I think, isn't it like Up in Smoke?
Yeah.
Movie, right? So if this was say like a possession of marijuana case, Cheech, he may say, hey, I don't think I can really follow the law because I think it should be legal and I will not convict anybody of it because he feels that way, right? Does that mean he's not going to be a good juror on a different case? No. It just means on that particular case, he knows from his own experience, from his own bias, that it is to such an extreme that he would not be able to follow the law as a juror, right? And that's really what we're trying to get to. Now, the charge in this case is aggravated sexual assault of a child. Okay. Is there anyone here who, when you hear that offense, you don't kind of like get a ick feeling, right? Anyone here who's juror number 4? Who doesn't get it? Yeah, like you kind of hear that charge. Yeah. Usually no one raises their hand, but again, we all tell the truth here. Right, so it's fair to say everyone agrees that this should be against the law, right? I mean, and would I want someone on the jury who didn't think it should be against the law? No, I would not. And so it's a difficult thing when you have a charge like this, because it's very normal to think of the offense and be angry at the thought of the offense, but still be able to, juror number 35, I'll call on you in just a minute, but still be able to understand that just because someone is accused of this horrible offense, they are still entitled to the presumption of innocence. They are still entitled to a trial. And as y'all sit here right now, you literally have no evidence before you, right? So it's okay to be angry at the offense itself. The question is whether you can understand that there's still going to be evidence and you're still going to have to put the pieces together and follow the law. Does everyone understand that? Now, specifically, juror number 35, before I forget.
I understand what the word aggravated means, sexual means, and assault means. Can you explain to me exactly what that puts together, what that looks like?
Yes. Yes, I can. There you go, my very next slide. So, if you are a juror on this case, you will be given the law at the end of the trial of what you will need to look at the evidence, and look at the elements that we have to prove. And for an aggravated sexual assault of a child, we have a date on or about, which is just that. It's not an exact date. It's on or about a date. This defendant, Juan Garcia son. Oh. Well, I don't know. I feel like there might be at least one or something. Okay. Well, I'll just keep talking. Maybe turn this screen around, see if it comes back on magically like it did before. There's nobody in the back, y'all can read this, but on or about a date, the defendant did intentionally or knowingly cause the penetration of the sexual organ or the anus. There we go. By any means. And that can be penetration with a penis, some kind of object, finger, just some kind of penetration. And it's penetration no matter how slight. So we refer to it as, I don't know if anyone knows geometry, but breaking the plane. So any kind of breakage of the plane of genitals or the anus would be penetration, no matter how slight. And then the aggravated, ma'am, comes from of a child younger than 14. So we're talking about a child who is anywhere from infant to 13 years old. Okay. Everyone understand that? Does that answer your question?
Yes, ma'am.
Okay, okay. I did want to talk about one of the judge's very last questions. She asked, and I believe something to the effect of who feels they cannot be fair because of the charge. Juror number 36.
No, just a second, pause. That wasn't the court's question.
Okay,
The question was whether or not if you were to be selected on this jury, if you could base your decision of whether someone is guilty or not guilty based upon what you hear. Because when you have certain charges, it could be a car accident, it could be a burglary of a habitation. Sometimes people have feelings about that. Sometimes people say, well, I just, can't deal with people who commit theft. Well, that may be how you feel, but the question is whether or not you can put that aside. And if you were selected to any of those type of trials, would you be able to base your decision on whether someone's guilty or not guilty based upon the evidence that's presented in the court? So that's the question. Thank you.
and the ones that I had recorded that raised their card were 3, 7. Let's see, you know what, let's just have your raise your cards. I'll do this again. 3, 4, 7, 9, 16, 28, 29, 11, 17, 33, 36, 41, 51, 43, 58, 59, 67. Now, of those that raised your card, well, you know what, we'll come back to you in a little bit. Beyond a reasonable doubt. Does anybody know what beyond a reasonable doubt is? It's a standard. It's the standard in criminal cases. Juror number 37.
Beyond a reasonable doubt is absolute.
Okay, so that is what I want to get to, because beyond a reasonable doubt does not have a definition. And the key words you really have to pay attention to are beyond a reasonable doubt. It's not beyond any doubt. It is not no doubt. Not beyond a shadow of a doubt. Oh my gosh. It is beyond a reasonable doubt. So the picture I have that you cannot see right now is a photo of a movie theater. So let's say you have plans with a loved one to go to the movies. I don't know what's coming out. Guardians of the Galaxy. Anyone seen that? Haven't seen it. So you're going, got your loved one, friend, and much like it has been recently, there's rain in the forecast. You're pulling up. Oh, it looks a little overcast, maybe getting a little dark on the horizon, but you go into your movie, watch your movie, and come back out, and you see a rainbow. You see cars in the parking lot that are wet. The pavement's all wet. Now, is it possible that maybe the fire department came and sprayed down the cars? Maybe there was some chemical spill. They had to spray everything down. Is that possible? Possible. Is that reasonable? And that's where the reasonable part of this comes. Because if you knew beyond any doubt, if it was absolute, no, beyond a shadow of a doubt, you would have been there. You would be a witness to this case. And frankly, no cases would ever get resolved. It's beyond a reasonable doubt. And what's reasonable to juror number 2 may be different than juror number 7. And that's why there's no definition. Because it's, you look at something and you say, do I have a doubt? And then you have to ask yourself, is that doubt reasonable? That's the standard. My picture is still not there. All right, I also have this really nice picture, these people can see it, of a puzzle, okay? And let's see, juror number 65. Can you tell what's in that, on that puzzle?
Earth.
It is Earth. And now there's some pieces missing, right? So we don't have all of the pieces. Is it possible that this puzzle might have like a big purple piece? It's not possible? Maybe it's an art piece. Maybe, right? But that's not reasonable. It's a picture of Earth. And maybe one day you'll see it. Now, I want to turn to children. This is a crime that involves children. I noticed a lot of you have children. A lot of you have adult children. Who here has children that are younger than 14? Hold your cards up. All right. 4, 8, 9, 11, 15, 18, 31, 33, 34, 39, 43, 44, 49, 54, 58, 61, 62, 63, 65, 66, 74, and 75. Of those of you that have children, who here has had a child who maybe has been bullied?
Couldn't hear you, ma'am.
A child who has been bullied at school. Let's see. Juror number 9. How did you find out that your child was being bullied? They told you? How soon after it happened did they tell you?
Well, I have 3 kids, so one's right away, the other
It took a while. Of all of y'all that have had your cars raised up, how many of you, your child told you as soon as it happened? So one of your child, 9, 13, 23, 32, 33. So that's a lot of kids who were being bullied who did not tell right away. So my question is why? Why would a kid who is being victimized in some way, why wouldn't they tell right away? Who said because they're scared? Juror number 4. And then keep your cards up. Juror number 62.
Shame or embarrassment.
Shame or embarrassment.
Maybe-
I'm sorry.
Maybe
67.
intimidated.
I'm sorry.
They may be intimidated.
Intimidated. 74.
Because I know that I tell them to tell me who their parent is and I'll go have a conversation with the parent.
Okay.
I'm not one of those that's gonna, that might be bullied.
Yeah. Juror number 1.
Thought it was their fault.
They thought it was their fault. Who else? Juror number 32.
I agree that they'll feel embarrassed or because I want to ask. Who was the parent or whatever.
They're embarrassed.
All right, so
35?
I'm sorry. If y'all can remember to keep your voice up because the court reporter has to hear and the interpreter has to hear.
The child didn't realize it was wrong at the time.
A good one. 36.
Child.
The child felt the parent wouldn't believe them. Juror number 39.
She thought she could fix it on her own.
Thought she could fix it on her own. Juror number 49.
You thought they would get in trouble too?
Thought they might get in trouble. Juror number 75.
But it might get worse.
It might make it worse. Juror number 64. It might have been threatened. Juror number 75. Can you expand on what you mean by it might make it worse?
That I would escalate it and children would retaliate based on, getting in trouble.
Okay. Retaliation. Maybe fear for themselves, fear of other people. Now, changing to the focus of what we're here today, a kid who has been the victim of sexual assault. Who here, I used to ask this question in different ways, but now I ask it this way. Who here does not know someone who has been sexually assaulted? Does not know. 15, 22, 41, 60, 63. Oh, yeah, no.
That's what I'm trying to figure
Do
not know.
This is obviously up to personal, whoever wants to raise their card, but of the people that know someone, whether it's yourself, a loved one, who here was it a complete stranger? Or number 7? Yeah, 62. So where do the assailants usually come from? The home. They're number 2, the home? Or was that your number 3?
Oh, with me, but
Okay.
it's usually the home or most predators are within the home.
They're number 74?
Like immediate family.
Immediate family, 17?
Family friend.
Family friend? 24?
School.
School, someone at school, yeah. 32?
If someone, someone says, not a family, just someone that's befriended you or,
Someone you know. 36? A neighbor? 61?
romantic partner.
A romantic partner. Now, we've discussed the fact that a lot of it comes from family, people we know, positions of trust, right? We're talking about a child. So is there anyone here? We talked about, why a child might not say what happened right away. Is there anyone here who will hold it against a child for not telling someone right away that they were sexually assaulted? Is there anyone here who will think, well, if they had been assaulted, they would have told somebody right away, so it must not have happened? So when we're talking about a child who has been sexually assaulted and they don't tell right away, what do you think happens to any physical evidence? Your number 24?
The personality will change.
I'm sorry?
The personality will change, your attitude.
Their personality might change, yes. Your number 2?
I think things that had happened, things would change on time. They may forget.
They might forget. Let me rephrase. So when I talk about physical evidence, I mean like clothes that they were wearing, underwear, DNA, maybe injuries on them, stuff like that. It's jury number 2. It's probably gone. Jury number 3.
Yeah, it's probably gone by then, or I don't really know, but it's probably not reliable at that point.
It wouldn't be reliable at that point. Jury number 4. Same. Anyone else? Any idea what happens to physical evidence after if a child doesn't tell right away? Jury number 10.
I was gonna say it's probably not available.
It's probably not available. Jury number 39.
It can deteriorate or get corrupted by other physical evidence. Other things.
Right, it gets corrupted. Kid changes clothes get washed, kid takes a shower. One question I neglected to ask. Of those who know someone, maybe even a child who's been sexually assaulted, who didn't tell right away, is there anyone here who knows someone who said something years later? 3, sorry, keep your cards up. 2, 3, 4, 5, 7, 9, 10, 11, 12, 13, 14, 16, 17, 20, 23, 26, 27, 30, 31, 32, 33, 34, 35, 36, 29, 38, 39, 40, 43, 44. I'm sorry, not 44, 43, 46, 48, 49, 53, 56, 58, 59, 62, 64, 69, 70, 73. And how many never told anyone? I never went to the police or anything. A lot. I won't take all of them, but a lot, right? When we're talking about a child, and that was for even adults, it's hard to talk, but we're talking about a child, we have special concern. You know, a child, say a young child. You know, we're talking about 13 or younger, but say even younger. How might they react to being sexually abused? Juror number 11.
Anger.
Juror number 16, anger. Juror number 11, confused. Juror number 13.
They will try not to be social. It affects them, especially if it's a family member.
They may isolate themselves.
Yeah. Yes.
Juror number 23,
Disbelief, association.
disassociation. Can you explain what that is?
Well, it means they sort of pretend it happened to someone else.
Okay, they kind of try not to think about it, right? Juror number 24,
Yeah, they will turn into the wrong crowd.
they might go to the wrong crowd. 28,
It might shut down lately.
might shut down completely. Juror number 10,
Probably, depending what the age is, increased promiscuity, maybe just go a little.
it might cause promiscuity. 32,
Or was it withdrawn?
withdrawn. 8,
They might play sexually inappropriately when they're playing, or they'll quit taking care of their hygiene. They'll wear big clothes that doesn't make them as pretty or as beautiful. And I had another one, it slipped my mind. Well, I said the hygiene, they quit bathing, they quit looking beautiful.
yeah. Juror number 3,
And not in all cases, but because I work with population, there are some kids that will act like nothing happened. You wouldn't even know. There's no change in their personality. They go on, and nothing ever happens. Sometimes there is no sign.
yep. And I was gonna get back to you, juror number 11. Were you the one that said confusion?
I was,
Okay.
I was gonna say they may repeat the behavior. Doing that wrong.
They may repeat the behavior. Do you think that if they're real young, that they'll even understand that it was wrong? Would it be? Whatever that's. If it's we mentioned that it happens between families, family friends. How could that affect whether they know it's wrong? Juror number 39.
It can be normalized, and it can be condoned, and it can be encouraged. And then they will seek that out later in their life as well.
Okay, thank you. Juror number 22.
They could have trusted that person. So if there is that initial trust, they may not realize that it was an act that was wrong.
Okay, thank you. Juror number 49.
They'll trust their family member and look up to them.
Juror number 35.
I'm going to use the word trust too, but I'm also going to say that sometimes the abuse doesn't hurt. And so they do not realize that it was wrong.
Juror number 36.
And sometimes child thinks that they might have caused it themselves.
They blame themselves.
Right.
Now, when a child does finally tell someone, we refer to that as an outcry. They've outcried to somebody. Anyone here had a child, might not be sexual abuse, but maybe it's bullying. I know we talked about the mom. But had a child tell you something bad has happened to them? A very vague question. Juror number 8. Is it, and you can see my questions here. Do they usually tell you everything, every detail of what happened all at once?
Not all the time, not every time. Some do and some don't.
So, so will they blurt it out all at once? Will you expect a child to know every detail that needs to be said? And then testing the waters. We talked about shame, trust. So is there anyone that would hold it against a child if maybe they only said a little bit at first?
The child will always be afraid to speak up.
Juror number 13, the child will always be afraid to speak up. Okay, this is kind of ridiculous. This is the first time I've used this feature. The one witness rule, when we're talking about a crime of this nature, where do those crimes typically occur?
They're isolated.
They're isolated. Ignore the picture right now. They're isolated, right? So who's typically going to be there?
The victim and the perpetrator.
The victim and the perpetrator. And who picks where it happens?
The perpetrator.
The perpetrator. Is it more likely, this is any crime, be more likely to get victimized in a crowded area in the courtroom here, or when you're alone? Alone, right? So we have this thing called the one witness rule. The judge did talk about it. I'm not going to spend a whole lot of time on it, but who here thinks if only one person saw this, if only one person testify, then I'm just not going to convict them. That's what the one witness rule says, that as long as we have one witness and you believe that witness beyond a reasonable doubt, there's still enough to convict. And if you believe that witness beyond a reasonable doubt and you don't, that's contrary to the law. Now I have this ridiculous picture because say you are mugged and you're by yourself and it is a man in a red chicken suit and dressed ridiculously, okay? And no one's there, there's no cameras, you know, he holds up a gun, takes your stuff, there's no physical evidence of anything. But you say, it was a guy dressed in a big red suit. And a couple hours later, sure enough, they find this guy and he's got your stuff, right? So it's kind of ridiculous, but a lot of people get hung up on it. And this is all to show, even though there's only one witness, it is still possible to prove a case beyond a reasonable doubt, okay? And this question is, for those of you who listen to one witness, in this case, a child, and you believe them beyond a reasonable doubt, is there anyone here who simply, understanding that it would be contrary to the law, but who simply just cannot convict someone on the word of one witness? Juror number 9, and juror number 10, and juror number 29. Anyone else? I appreciate your honesty. Okay, and judging credibility. So how do we judge a witness, right? Common sense, body language, facial expressions, corroboration of some sort. Their motive. What motive would they have? So evidence in this case, what kind of evidence do you expect to see in this case? Anyone? We just talked about a witness, right?
Testimonies.
Testimony is evidence, 67, 62.
And bodily evidence, if there was any.
So if there was any bodily clothing, what about, juror number 32?
And how was it, like, timeline?
A timeline? Juror number 35?
Expert witness like a psychiatrist.
Okay, expert witness. 47? There might be DNA. Is there necessarily going to be DNA? Juror number 47? Okay. Anyone else think, like juror number 47, that even in an instance where maybe the child doesn't outcry right away, you would still expect to find DNA? Juror number 62, it depends on the situation. So it's possible, right? But who here would say, I expect it to be there? And that's fine. This is, trust me, I want y'all to tell the truth. Who would expect it to be there? Juror number 47. Okay, thank you. And then, I'm sorry, someone had their number up. 24.
A video.
A video, maybe?
You have a juror over here.
Oh, I'm sorry.
Yeah, I was gonna say medical evaluation.
Some kind of medical evaluation. So put it together. You're gonna have the law, you're gonna have the testimony. You'll have your own common sense, your own view of what is reasonable. And you'll put it all together and render a verdict. Now that leads us to the second phase of this. After the guilt innocence, there is a punishment phase. And the punishment for aggravated sexual assault of a child is 5 years to 99 years in prison. All eligible. Now, punishment, there's a range, right? Can someone tell me why there's a range in cases? Why that's important? Juror number 17?
Based on the severity of the case.
Based on the severity of the case. Juror number 10?
Based on the circumstances and what evidence was presented.
Okay. Juror number 2?
I would say based on the evidence that's.
Okay. In a sexual assault of a child, what kind of circumstances might lend it to a lower range or a higher range? Juror number 17?
Many times it happened.
How many times it happened? Anyone else? Juror number 67?
Maybe there was like a permanent damage.
If there was some kind of permanent damage. Juror number 10?
The age of the victim, age of the perpetrator at the time.
The age of the victim and the age of the perpetrator at the time, right? You have a 19-year-old and a 12-year-old, or a 12-year-old and a 60-year-old, right? Juror number 63.
There's any history of prior conviction, prior assault, any other prior.
Right.
Prior to
Consideration of any kind of prior offenses, right? And that all comes out of punishment. Obviously, you don't know anything. We're talking possibilities. Why could it be this? Why could it be that? But you don't know anything about this case. So it's important going into it that you understand that. There may be cases, I give the example when we're talking about a murder. Murder has the same range, 5 to 99. Well, it could be two drunk brothers who get in a fight and maybe one punches a little too much, right? Or it could be something awful, a complete stranger who horribly murders a child in the back of an alley. Those are going to have very different, maybe the minimum to the maximum. Is there anyone here who simply will not consider a minimum in this case? So that's juror 1, 3, 4.
And I'm sorry, just a second. When she says, consider, it is not in this case because you don't know anything about this case. Does everybody understand? And as I told everyone before, it's not whether or not you will give somebody 5 years for an aggravated sexual assault of a child if you found them guilty. It's whether or not you acknowledge this is the range of punishment, that you're going to keep an open mind if any type of aggravated sexual assault case of a child goes to punishment. You keep in mind the full range and you keep an open mind and you listen to the evidence, then make a decision. Does everyone understand? Because my understanding, and maybe I'm incorrect, the state was giving you different age range that could be an aggravated sexual assault. They're giving you hypotheticals and people were saying, oh, well, that's something maybe I would consider the lower range, or that's something maybe I consider the higher range, but it's not to actually give someone time because you don't know any evidence. And again, when the state and the defense are talking to you, it's hypotheticals. It's not about this specific case. Does everyone understand? All right, state, you have 4 minutes.
And as soon as I said in this case, I knew I said it wrong. It is in general. Anyone here in general, not absent from what may happen in this case, understanding that there are aggravating and mitigating circumstances in every case. Is there anyone here who says, you know what, I can never give 5 years? 1, 3, 4. Is there anyone here, you would not be able to give the 5 years? Okay.
And again, it's not everyone, it is not give, it's consider.
Consider. Yes.
So it's not giving anybody punishment because you don't know anything about an aggravated sexual assault. It's sort of like with if you have someone who's charged with murder. The range of punishment for murder is 5 to 99 years or life. There are different types of murder that happens. Maybe there's a murder case where someone has been terrorizing the neighborhood and maybe someone shoots them and they die. And they were not justified in shooting them. You will listen to the evidence and maybe you will say, well, this person, this complainant who was killed, they were terrorizing the neighborhood. They kicked the dog down the street. They killed this person's bunny rabbit. But yes, this person is guilty of murdering them, but maybe you don't want to give them a life sentence because you're looking at everything. And it's the same thing with aggravated sexual assault of a child. It could be someone who's being accused, could be a teenager. You can have a teenager charged with aggravated sexual assault of a child. And who knows, maybe this teenager who's charged with aggravated sexual assault of a child, maybe they were abused in their past. This is what happened to them. So it's not whether or not you're going to give a person 5 years, 6 years, 7 years, 8 years, life, or 99 years. It's whether or not you acknowledge that this is the range of punishment. And would you be able to keep an open mind if somebody were found guilty and listen to whatever facts that are brought to you in punishment and consider that full range? Does everyone understand? All right, state.
Yes. And again, I should have played my whole slide. Is it possible that there are facts exist that could give the minimum? And is it possible that facts exist where you could consider the maximum? Okay. So juror number 2.
Yes, I was, until it was explained a little bit more. I was myself, I had to hear the whole story.
Right. So is there anyone here who is listening to this and is saying it depends in their head? Yeah, then that, and that's exactly what we're getting at, right? It depends. It depends on what the facts show. It depends on, the different factors we talked about: age, priors, non-priors, relationship, all those factors. So that being said, I hope it's been clarified now. Who here just cannot consider the possibility that there are a set of facts that would justify a minimum the 5 years in this case? Jurors number 3.
Everyone, it is not giving the punishment, it's considering. All right, states, you may proceed. No, yeah, it's not giving, it's considering the full range of punishment. Does everyone understand? Not this, not the person who's accused here.
Right.
These are all hypotheticals. So here's the question. in an aggravated sexual assault of a child. Hypothetically, let's assume someone has been found guilty of that by a jury. Everybody's following my hypothetical. All right. The range of punishment is anywhere from 5 to 99 years or life. Does everyone understand that? Now, it's not whether or not you can give somebody 5 years or give them life. Think of different scenarios in your head. As I said, there's sometimes a person is a teenager and they're charged with aggravated sexual assault of a child. Sometimes that teenager themselves have been sexually abused by someone. Will you be able to consider the full range of punishment in that hypothetical? Is there anyone who cannot consider the full range of punishment in that hypothetical? All right, so call out those numbers.
Okay, keep your cards up. 3, 7, 11, 17, 20, 28, 29, 36, 49, 51, 58, 60, 61, 67. Number 3, I gotcha. Okay. Is there anyone here who could not consider the maximum specifically? Any reason you feel that we've discussed about that you would be unable to listen to the evidence, to follow the law, and therefore would not be able to serve on the jury? Number 3, 7, 9, 10, 16, 17, 20, 28, 29, 36, 58, 59. Any other questions? I think my time's up.
Yes.
Okay.
All right, defense.
Where is hers? Where then do you see his? Oh, right
You
there.
may,
Right there.
okay,
There we go.
I'll start you once it's set up, Mr. Leo. And to the interpreter, if you ever need a break, just let me know.
Yes, my replacement is on her way, Your Honor.
All right, are they on their way now?
Yes, she said a few minutes.
All right, so everyone, what we're going to do is we're going to take a short recess because as you can imagine, the interpreter needs a break as well because they're saying everything that everyone's saying. And so I don't want to say her job is harder than the court reporter, but it's neck and neck. And so she does need to take a break. So we're going to come back at 4:20 because the interpreter who's coming down is coming from upstairs. So you can leave all your items here. And again, look to your left and right. Make sure you bring your buddy back with you. Everyone, please rise.
And I just wanted to.
We kick off people.
Did like a all-day voir dire and the next day she was hiding from the media.
gonna
So
end
we
up-
just sat around doing nothing. So, it was in this. I told him if anything, in Facebook screenshot pictures, we posted on Facebook, like.
Not go well for her,
I don't
that's
like
for sure.
keeping-
Thank you so much. I appreciate it. Appreciate it.
All right. Very well.
Oh, Mr. Plea. And stay, if you can come forward for a second. Yeah. All right, okay, I think we have everyone. All right, defense, are you ready to proceed?
Oh, yes, Your Honor.
You may proceed.
Thank you. Good afternoon, ladies and gentlemen. This is a great group. It's seldom that I have a group of people that are very talkative. And I like that, and I'm sure that the state and the defense likes that. And because in some groups, you know, after spending an hour in the hallways, couple of hours and being heard like livestock, you know, you can tend to get, you know, in a not very optimistic mood, right? But luckily you have kept optimism, right? So that's good, that's good. My name is Rafael Leal, and my partner Brian Kimbrough, present here. We represent Juan Antonio Garcia Sanchez. And this is a very important, as you might have mentioned, part of the process, because this is when you get to talk to us. This is the only speaking part in this whole process until you hear all the evidence. You go into the back room, the jury room, and hear, you know, after you have taken all the evidence, and then you render a decision. So before you know, you do that, we have very important questions to ask you, and I hope to get some very good answers that you're responding to, in order to, you know, concerning the very important issues in this case. So it is also very important to my client, Mr. Garcia Sanchez, because this is, so to speak, his day in court. And that is important that I ask the appropriate questions and get responses from you, and you've been very forthcoming, and I like that. So therefore, one of the issues in this case is that Mr. Hernandez, if you were to need a lawyer or a member of your family need a lawyer, would you like that lawyer to be very thorough in this stage of the trial?
Yes.
Ask all the appropriate questions?
Yes.
What do you think about that? What should a lawyer like myself go through these questions in a case like this? If you or a member of your family were facing this type of charge, what do you think? Why should a lawyer be that thorough? Or ask questions as necessary and take as much time as necessary for you and the other lawyer and the other people to answer questions.
Just to ensure a fair and impartial. Sorry. To ensure a fair and impartial jury.
Okay. Number 9, what do you think about
Your
that?
life depends on it.
I'm sorry?
Your life pretty much depends on it.
Right, anybody that feels like Ms. Garcia? 24?
Yeah, it depends on your child. It's your child, it's not your child, then to make sure they send it to them.
Okay, number 10?
Yes, I mean, like you said, your life depends on it and it can change everything.
Correct. Number 32? Until all the facts are presented, because does a lawyer representing, in this case or any type of case needs to be as thorough as possible and get to all the issues affecting a given case, such as this case, in order to ask the appropriate questions, in order to get answers to issues that affect the case. Right? What do you think? Number 6. Mr. Hernandez? What do you think about that? Should a lawyer be as thorough as possible? If your life depended on it, or the person, a member of your family's life depended on it, on the lawyer being as thorough as possible, make sure that nothing slips by that is important to bring up before the court. What do you think?
Whatever decision is made at the end.
All right, I'm sorry. Excuse me, just one moment. I'm gonna have to ask you to keep your voice up because the court reporter can't hear.
Whatever decision is made at the end, that's gonna impact that person, whether if the evidence was thorough or not. And if they make the wrong decision, then that person's gonna be indicted wrongly.
Okay. Ms. Lopez, what do you think about what Ms. Hernandez says?
I think that's fair, like, you should, or the lawyer in this case should ask all the questions and inform. Because as we've all mentioned, for those who have spoken, your life depends on it, and the decision that is made is important.
And literally, this type of case, and literally, as you have heard from state, this type of case is anywhere from as low as 5 years all the way to 99 of life. Should we spend as much time as we need if your life or a member of your family life depended on it? Ms. Lopez. On Ms. Cooper, I'm Lopez. Oh, you're Lopez. I'm sorry, okay. So, Ms. Cooper.
Yes, that, to answer your question, taking the necessary time needed. We ask all the questions and to review every evidence to make the decision at the end.
Okay. Lopez, now I got it right. What do you think about what Ms. Cooper?
I agree.
You agree with it?
I agree with it.
Do you have anything to add to what she said? No? Okay. So, anybody else that thinks like Ms. Cooper or Ms. Lopez, that we should spend as much time as possible exploring all the issues and raising all the questions and be as thorough as possible, so your life or your family members' lives and constitutional issues are being addressed to the fullest extent. You are not in the 47. But 47. Do you have a comment to make?
Life depends on it, and you gotta let the thought back, you gotta be open-minded.
Okay. What's it?
Well, I mean, to the point for all of us, whatever the result is at the end of the day, we all have to live with the decision that we made.
Yeah, that's correct. And who else thinks? Do you have another opinion or comment?
I think everybody deserves a fair trial, and they deserve the best lawyers possible so that they can have as much an opportunity to state their case as possible.
Right.
I think that's the American way to have a fair trial.
It's definitely a matter of justice, right? If you don't want to make the wrong decision, I mean, you want to make sure the justice is served. So a right jury, right people, outline any biases and identify any biases.
So do you agree with me that we should explore all the issues in the case to the fullest extent to make sure that the jurors that are ultimately selected, so they're going to this jury box, get all the facts necessary for them to make the right decision? You agree with me on that?
So, yes, sir.
You have a comment to add?
No, I just said yes.
Yes, okay. Anything you would like to add?
I mean, I agree. I mean, your job as a lawyer is to defend to the full extent of the law, and
And you would like for that lawyer, if he were defending you or your family member, to be as thorough as possible?
better.
Better do that, right? Okay. And Matthews, okay, Mr. Matthews. Do you think that people have strong feelings in sexual abuse cases of a child?
Do you have strong feelings about something
Yeah,
like
because,
that?
people in general, and nobody likes to I mean, this is different than an accident, for example, or a DWI, when no accident happened, is that reason? I would. What do you think about, do you have any opinions, or do you have anything in your background that will, or do you agree that people that should disclose things in their background or experience that may prevent them from looking at the evidence with clear lens because of those experiences or the strong opinions they might have concerning that type of a case? What do you think?
Well, I definitely think people's experiences definitely have an impact on how they're gonna view the case.
Do you agree with me that that what may cause to a large extent is the experiences we have had?
Absolutely.
And who else agrees with Mr. Matthews? Okay. I heard from number 11, can you tell me something about or do you agree with me that people who have had experiences that may affect their decision, however slight, should disclose or talk about it in private if necessary, concerning their strong opinions or for this type of occasions or for their previous experiences? Yes?
Yes.
Okay. have you or any member of your family been affected by being assaulted in some form of fashion? Have you experienced that?
Are you asking me?
Yes.
specifically? No family members, no, sir.
What about you?
No.
No? Okay. Understand you raise your.
Yeah, I've had friends and family members
Okay,
impacted by something like this.
all right, and do you think that some type of that type of experience that your family members have experienced may in some slight fashion favor one side or the other in this type of things?
I also have people on both sides accused and.
Okay. And who else agrees or disagrees with Mr. Jackson? Number 10. Okay. Number 13.
What's the question?
The question is, do you believe that people may have strong opinions or have had prior experiences that may affect how they view the evidence in this type of a case? Okay. All right. Number 12. Can you tell us about
Feel like it's already been said pretty plainly, but if you have had a personal experience, then you potentially have a bias, whether you've been a victim or you've been somebody who's been accused, you would have had that experience in your life, and then that whatever that experience was could create a bias.
Okay, who else thinks like number
12.
12. Number 12, 13?
I
What do
agree.
you think?
I agree, because everything is, it all depends on how that person reacts. If there were either personally or it was a family member, and I agree, it could be either side, but it depends if it still affects you. Because this kind of case, it'll affect everybody. Because everybody will have some kind of opinion. Because it's dealing, we don't know, it's hypothetically what the age is or what the situation was.
Go ahead.
But my personal opinion is yes,
Okay.
it would affect
You
as
think,
someone.
you think that a person with a strong opinion or that type of experience would be a good juror in a case like this?
Probably not. But it just depends, everybody's different.
Correct.
And they might want to see justice in some way or fashion, actually seen and dealt with. But and until we know the case.
Do you know, who else thinks like number 11 or 13? 13. Can you raise your 29, 36, 20, 12, 19, 8, 23, 24, 7? Okay. Now, let me ask you a question, okay? Like, experience?
Yes.
Okay, this is experience, okay. Raised, right. Conley? Roger?
You say the number first so that I can.
Number 14. Discuss this. Do you know, or what would you think that there might be cases where a juror may not be a good juror because of strong opinions about the type of charge or prior experience that may affect how that potential juror views the evidence. He or she might be a good juror for another type of case, but not for this type of. What do you think about that?
As the judge had told us before, if like if somebody got into a car accident and this was involving a car accident, they might not be a good fit. So,
Right. So you think that a juror should disclose those strong opinions and
disclose their opinions possibly, but that's a tough question. I mean, not everybody wants to come forward with whether it happened to them or whether it happened to a family member.
right.
It's very
Okay.
personal.
Well, just so everybody, if there is something that you don't want to disclose in public, we can always approach the judge. You just have to ask us, so we know, and then we can approach the judge, and then we can ask those questions. Number 36.
And one of those people then needs to approach the judge and has this.
Okay, we need to approach the judge. Okay, we'll do that. Anybody else? Number 7, number 1, number 9, number.
Oh, sorry.
Number 13, 16, 19, 17, 20, 29, 35, 23, 58, 36. Anybody else? Here, 64?
Is the question whether we want to disclose privately?
Right.
We don't feel comfortable disclosing.
Correct. Any prior experience or strong opinions you have about this type of a case, just because of the charges and because of the opinions that you may have had? Because we just want to ask you your thoughts about the issues in the case, and you can say in this court whatever you want. Okay? There are no wrong or right answers. Okay? But if you if you don't feel comfortable in disclosing your experience or the reasons behind your strong opinions, then we can always approach the judge and talk. Is that something that we would like to do?
No, I have no problem saying when I need to.
All right. Anybody else? All right.
No, I wanted to answer, to the question, a couple of questions.
Okay.
Kind of, I think the way, we all agree, like child assault, child abuse is wrong. We all, I'm not speaking for everybody, but I'm saying all in general, we all believe that. But I think in how we handle it deals on how we've dealt with it. Did we address it through therapy? Did we address it in the justice system? Or did it go hidden underneath and now, oh my God, this is the first time I'm having to divulge what I've experienced. So I think the way the family members or the person themselves or their loved ones or circles, the way they dealt with it will determine how they react to it when presented in a court. Is what I
Correct.
think.
Correct. Well, it feels like number 8. Okay. Let me ask, because you've been very nice, very good panels, and because let me tell you a little phrase: those who talk walk, those who remain silent stay. So, I'm sorry. Okay. Okay, now, so for you would be be selected, not selected, but be selected, and will hear the evidence. And you will be like a judge of the facts. Okay, you're gonna be like Judge Boyd with a black robe. You will be judges of the facts. You are the only ones that can determine whether something happened or did not happen. Okay, based on the evidence that you hear from the witness stand. Okay? And there's only one question that you're gonna have to answer with all the evidence that the state is gonna present. And that's whether or not they've proven the charge that they brought before you with beyond reasonable doubt. Okay, that's the only question, if they prove it or not prove it. Okay, and that's what you're gonna, you're gonna either say guilty or not guilty. Okay, based on the evidence that they presented. There was a question that was presented by the state concerning whether you could base your decision based on what you hear and the evidence presented in the courtroom, and a number of you raised your card saying that you could not. And I like to call those yours. The new was number 3. Yeah. Okay. Can you tell us a little bit about it?
So basically for me, I currently work, I give counseling to kids who have been.
Counseling to what? I'm sorry.
I give counseling to kids who have been sexually, emotionally, physically abused. So I currently work at RTC right now. And so then I've also experienced it myself. I've had close friends and family, so it's too much of a topic for me to not leave out my biases at this point, because I'm in the thick of it right now. So I've come to the court with kids, like, so it's just like, so that's where I'm at.
Thank you very much for telling us that. And anybody that feels like number 3, you're number 3. Number 9, what can you tell us?
Well, I did too. I went through stuff as a child too, and then not too long ago, I also found out that my daughter went through something like this, so I want no part of this at all.
Can you think that because of your prior experience and that this may not be the case for you?
Absolutely.
Absolutely not. Okay. Anybody else? Okay, number 16. Let me go through the process. Number 16.
His personal reasons, me as a child and my daughters.
Your daughter went through something like that?
Both my daughters,
What did your daughters?
yes. So
How old are your daughters?
now they're older.
They're older?
Yeah.
So years ago?
They were younger, yeah.
They were younger? Okay.
Me when I was younger.
You when you were young? Okay, so based on those personal experiences, do you have strong feelings about the type of the case?
It would affect me too much to compare something.
I can't hear, I'm sorry.
It would affect me too much to hear something like this, another child who go through this. Since our family went through it.
Okay, you have like, do you feel like the bias you have, and it's okay, I mean, all of us have
I did
bias.
bias towards it,
So the bias you have may affect, may tip the scale one way or another?
Yes, sir.
Okay, thank you very much. Anybody else? I think you mentioned something like that. And thank you for being so patient.
Based on personal experience, I wouldn't be able to be biased.
Based on your personal experience?
Yes.
What?
I wouldn't be able to be biased in this case. I wouldn't say, I'm biased, I'm sorry.
Oh, you're biased because of personal experience?
Yes.
Okay, so based on your personal experiences, do you think that your decision in this case may be affected by those bias?
Correct.
And your vote may be affected, keeping the scale one way or another?
Yes.
Okay, anybody else? Okay, hold it. 13, 23, 13, 20, 29, 36. Anybody else? 58, 7, 52, 51, 59, 67, 64. Okay. Keep your. All right. Yeah, number 3, obviously. Number 7, what can you tell us? What can you tell me about it? I mean, do you have a bias for this particular case or against this particular?
Yeah, so as soon as I heard what kind of case it was.
Okay, can you tell us a little bit what strong opinions you have or, and you use the word bias, but I mean, what kind of bias you think you have?
That something like this happened to myself, as well as
family.
Okay. And your previous experience within your family may affect how you make a decision in this case?
Yes.
Okay. Keeping the scale one way or another, perhaps? Okay. I'm sorry, number 13,
Same.
the same? Okay. You also have that strong body, number 20? You also have that personal experience?
I do.
Okay, maybe
I can't tell.
you will
I
be a
cannot.
parent.
All right,
part of
sorry,
your-
sorry, just 1 second. So here's the problem we're running into. Everybody is now making people's job more difficult than it has to be. And this is why I say that. Number one, court reporter can't hear. If the court reporter in a case doesn't take it down, didn't happen. So everyone needs to make sure they talk one person at a time. And counsel, if you could, when you're talking to somebody, if you're not staying in their path, because it'll make it easier for the court reporter to hear. Next thing, we have an interpreter. And when everybody speaks over everybody, you're asking that interpreter to talk and say what everybody's saying. She has to say not only what each of you are saying, she has to pick up and interpret even the side conversations. And that's hard for her to do because then you are now asking her to interpret what 4 people are saying and making sure that the equipment is working so that Mr. Sanchez can hear what's being said. So it's getting late and we will be here as long as we need to be here, but the process will move more smoothly if everyone will remember to talk one person at a time. And everyone, when you are ready to talk, just hold up your card and defense will call on you. And defense, if you could call on them by their number, because the court reporter does not like to have a record where it just says Vernier person. If it's number 6, 5, or whoever it is talking, it makes their record cleaner if they can put the number in. And believe it or not, when court reporters have a record and their record says it's inaudible or their record doesn't signify who's speaking, that reflects badly on them. And then people say, well, we don't want that court reporter because things are inaudible. So let's not make her job any more difficult for her or the interpreter. All right, you may continue.
Thank you. You were number 20, right?
Correct.
Okay. And let me ask you a question. When it comes down to making a decision whether guilty or not guilty, your personal experience or bias for this particular offense may, however slightly, tip the scale one way or another for making that decision?
It wouldn't be slightly,
It will be slightly, it will be a lot?
yes.
Okay. All right. Who else feels like number 20, 29, number 13, 29, 29? Can you tell us a little bit about it? We're gonna, number 36, you want to talk in private or you want to discuss it here? I mean,
Just making sure that I get addressed and that I don't be left in and then somebody puts me on.
I can't hear, I apologize. You stand out, thank you.
I'm concerned that I'm gonna be left by the wayside and that I will not be heard and I'll be put on this jury when I do not feel comfortable at all being in this trial because of the experiences I had as a child.
okay. And you think that because of those experiences as a child,
It
when it
makes
comes
me extremely biased.
extremely
Extremely
biased,
biased.
okay. Thank you very much. I appreciate it. Number 29.
I have no tolerance for sexual predators. Just being here, in this presence, I'm disgusted.
All right, stop right there. Time out. Here's the thing. You don't know if somebody's guilty or not guilty of anything. Do you understand?
Just the mere fact that.
So no. Here's the question. The question is, you are here potentially to be a juror on a case to listen to evidence. You don't know whether someone is guilty or not. Do you understand?
Of course, I understand.
So for you to say that you're in the presence and you don't want to be in the presence of this person, you don't know who you're in the presence of because you haven't heard any evidence.
He is accused, isn't he?
You have not heard any evidence in this case. And I asked beforehand if everyone had to vote right now, what the verdict would be. And everyone said not guilty because they had no evidence. And no evidence has been presented to you. Now, I'm going to go back to what I said again. In defense, I've paused your time. I understand sometimes people don't want to be in a jury trial because you have other things you want to do. There are other things you'd rather be doing in your life. Maybe you want to be at work. Maybe you want to be at home doing your dishes or doing your laundry, picking up your children from school. But this is the jury system of the United States, and you cannot have a jury trial without jurors. I hear people all the time on TV walking down the street talking about how great this process is. You cannot have a jury trial without jurors. And for people, maybe, to say things just so they can't be on this jury panel, what's going to end up happening is that your jury duty will not be completed. You'll be brought back tomorrow to go on another panel. So for anybody who's here today, when I ask the question whether or not Mr. Sanchez was guilty or not guilty at this point in time, everybody said not guilty. And the reason why you said not guilty is because you have not received any evidence. There are plenty of people who end up going to prison and they have been later determined due DNA or whatever that they were not guilty of the offense that's charged. So you have no idea who you're in the presence of. Right now, what you're in the presence of is somebody, the state of Texas versus Juan Sanchez. That's it. I told everybody that an indictment is not evidence of anything. Because if it was, guess what? We wouldn't be having a jury trial. You'd say somebody got indicted. Oh, well, they're guilty. Somebody got a traffic ticket. Oh, well, you need to pay it because you're guilty. That's not the way the legal system works. What is your juror number?
29.
All right, you may have a seat. Defense, move on to your next person.
Thank you. That leads me to the next question that I have. How many of you have been falsely accused of doing something you actually didn't do? Can you raise your hand? Or you know? 66, 2, 8, 10, 21, 30, 45, 48, 49, 53, 46. Anybody else? Okay. How many of you have actually been punished after being falsely accused and then punished or doing something you did not actually do? Anybody? Oh, 70 and 66? Okay. Anybody else? 53, 48, 46, 45? Okay. How many of you have accused someone of doing something and punished that person and later found out that the person did not do it? Anybody know that? Self-disclosure. That actually happened to me, okay? I also do divorces, not as much as I was doing earlier, but my client brought me an USB with evidence that, and I was representing him, evidence that his wife then was videotaping herself doing things with another person. And he showing the private parts. And at first I didn't know what I was looking at, so I plugged it into my computer, to my desktop. And obviously those of you that have done that, it's synchronized and downloaded automatically those files into my computer. I closed the case, got him divorced and all of that. And weeks later or months later, I was charging my telephone, my cell phone. And those files, unbeknownst to me, transferred to my telephone. And then my wife was going through my telephone looking for something and saw those files. And then before she even asked me a question, or, you know, what is this or anything like that, she slapped me. Like, what did I do? Okay. Then she showed me this, she showed me the cell phone, and then I put two and two together and realized that the files, when I was charging my telephone through my computer desktop, had migrated to my telephone. And I was not only falsely accused, but almost executed. You know, I finally was able to tell my wife, and we made up and all of that, which was right. I was punished. She slapped me twice. Okay, anybody that has happened, not maybe something like this, similar, but you know, like somebody assumed something you were guilty of, and then slap you, punish you in some way, and then find out, hey, my husband or wife didn't do it. Can you tell us about it? Number 10?
Anybody that marries.
Okay,
I can't hear.
can you tell us about it?
Similar situation.
Similar situation?
A phone call, strange number, a female voice, you're in trouble.
Exactly, okay. Something that you would probably mention or something like that. Number 27?
So like, what I do utilities,
Uh-huh.
so like they hit a gas line, and I wasn't even present, and they fired me for it, because I'm supposed to be the spotter, but I wasn't even present, I didn't even show up to work, I was gone. And
Okay,
they
so
fired me
you
because I
were-
was, yeah. They let me go because they thought I was the one that was watching the excavator, and it wasn't even me, so they let me go because they blamed the spotter instead of the operator.
Hey, do you remember how you felt when, you know, you were not only, you were assumed to be guilty, you were fired, you were punished? How did you feel?
I was angry, but I was more of like this, please, because I've been working there for already 2 years and I had no problems, and they let me go for a reason I wasn't even involved in, and I wasn't even present at work. And
Okay.
even with an excuse that I wasn't there at work, they didn't believe it, and they put all the blame on me.
Okay. Who else, something similar happened to somebody else? Number- Somebody raised their card. On your card?
I'm married, so I mean, I've had phone calls, I've had, you know, texts from strange people that I was,
Number 23?
I'm not stranger, you know, I mean, texts taken out of context, both incriminating. So, wife did what a good wife would do. So that was guilt.
How do you feel about being assumed to be guilty or accused of doing something you didn't do?
You know, I'm first, I'm insulted, I'm offended, and I get it, and I understand completely.
Okay, and number 39?
I used to work in the animal care industry, specifically with keeping them safe and cared for. And there was a situation where a dog's leg got broken, and everyone that was there was accused of it at one point. Everyone that worked there, regardless of their shift, because the CEO needed to find someone who did it. And it turned out it was an accident. It was someone that was a new hire. It was a bad form of conduct, but it was something that just happened and was covered up.
Okay, but were you accused of doing it, or you accused somebody of doing
Everyone was accused of doing it.
it? Okay, in fact, not everybody was guilty, right?
No.
Okay. All right, anybody else? Number 35?
I'm in education, so parents blame educators for everything. If their child didn't do their homework, it is.
And that's. Let me ask you, you're like a teacher,
I'm the assistant principal.
assistant principal, so. You probably have had lots of experience with teenagers, students, that type of job, because of the job you
I've been
have
in high school.
during high school? Okay, and, how do you determine, I mean, when people accuse a teacher or another student, how do you go about,
You investigate.
you
You
investigate?
investigate, yes, sir.
You ask all the parties or you all
Yes,
ask all
you
the students?
investigate to the fullest extent. You get everybody involved, you get as much information as possible, and you go off that investigation.
Now, what are the, high school and middle school were different when I was going through it a long time ago, as you can tell. There seems to be more rules and regulations now. Why do you think that is the case?
I mean, society is different than from when we went to school. A lot of things are happening, social media, there's a way to. I mean, it's just so much is happening, so much has changed since the 70s when I was in high school. And so there needs to be some regulations put in place so that we can make sure that all of our students are safe.
Have you dealt with cases with, people wrongly accused one student or
I
accusing
see
a
it every
teacher?
day.
You see it every day?
Yes, sir.
Do teenagers lie?
Teenagers lie and adults lie.
Everybody lies, that's correct. And do they lie about
They lie
Every-
about everything.
everything, including sexual
Yes, sir.
things?
Yes, sir.
Okay. And, anybody else? Any other teacher? Thank you very much. Are you a teacher number 23?
Yes, sir.
Okay. And, do teenagers in school lie?
They've been known to.
Can they know to? Okay, do they lie about, all kinds of things, including sexual?
This thing to my left is, I'm gonna echo her sentiment. Teenagers lie, adults lie. Parents lie.
Okay, let me ask you, two people are in a room, there is no witnesses. And one person says that they were inappropriately coached. The other person says, I did not do it. They bring that person into court. Sitting here in trial. How can you prove something that you did not do it? How can you prove a negative?
There's only those two people in the room and there's no other recording equipment.
Okay,
Seems like it'd be possible.
okay, anybody else that?
What did you say?
Seems like it wouldn't be possible.
Okay. Would you expect to see some kind of physical evidence perhaps? In support of a claim that he did something to me?
Could be, but not necessary.
I'm sorry?
Could be, but not necessarily.
Could be, but not necessarily. Anybody else that thinks like, what do you think? Number 15. You're not a teacher, are you?
No,
Okay, what kind of work do you do?
an event manager at a hotel.
Okay, what do you think about what this?
That all people lie.
People out there.
I think all people are capable
Well-
of lying, whether they do it or not.
The question is, that I asked is that two people are in a room, there's no witnesses. And one of them says, he touched me inappropriately. The other person says, I didn't do it. The person is brought to trial. How do you prove a negative? How do you prove, how would you prove that I knew that you did not do it?
Well, you would have to know all the facts before you could prove anything.
Well, I'm asking you, how would you prove, what would you have your lawyer do to prove that you did not do it?
I don't know.
Yes, thorough as possible, right?
Mhm.
Asking questions, right? I mean, that could be one way. Would you agree with me?
Yes.
All right, number 48, thank you.
physical evidence, yeah, if you see anything torn, injuries or whatnot. And
Okay.
it doesn't make it 100% true, but
Uh-huh. Okay,
I don't know where it is.
all right. Well, do we all agree that number 39?
Prove innocence in a trial, the burden of proof is on the prosecution to prove guilt. Or innocent until proven guilty, the burden of proof is on the prosecution.
Anybody that thinks like number 39? On the fence? Somebody.
I agree with what she said around the burden of proof is on the person making the accusation, right? The proving it, going back to your other question too, proving a negative. Basically, you have to first figure out what the two people agree on. What facts are agreed upon, and then where's this disputed, and then you can see there's a reasonable doubt for the circumstances there.
Okay,
All right, defense, that's 45 minutes.
I still have a bunch of questions, George. Do you want me to list them?
That's 45 minutes.
I know, but I have a couple of questions. Do you want me to list them?
That's 45 minutes.
Am I being overruled during those
Yes,
questions?
that's 45 minutes. Both sides agreed to 45 minutes, counsel.
I did not agree to 45 minutes. Instead said 45 minutes.
Yes. All right, ladies and gentlemen, I'm gonna have you all step outside and everyone, please take your personal items with you and leave your numbers behind. No.
Whatever. Yeah.
Come on in. You can sit anywhere, just go all the way to the end. You can sit in the bench. Okay,
Really wanted to get
just go all the way to the end, make it everybody easier when they walk in. All the way to the end, to the end, to the end.
So,
To the end. You guys should squeeze together, because not everybody's gonna have a squeeze. Oh. It's easier for people to walk Not everybody's gonna have a. You're gonna get selected. So 12 people. Not everybody's gonna have a seat. Not everybody's gonna have a chair. So you're gonna-
All right, everyone, please be seated.
Let's move forward.
And we're on the record. All right, ladies and gentlemen, thank you for participating in jury selection. As I stated before, we cannot have jury trials without jurors. I believe Deputy Mejia or someone may have already given you your excuses. Those are the little white sheets. Please make sure you have that. The only exception to that excuse is juror number 29. Juror number 29, where are you? All right, juror number 29, you'll have to come back tomorrow. All right, so with regards to those sheets that you've been given, you will receive a payment for your time here. Of course, I know it's not a lot, but you can use your payment to you can donate it, and there are plenty of organizations you can donate it to. Or what will end up happening is later you will receive a check in the mail, probably 2 months later, and you will wonder, is this true? Is this a real check? Then you're going to remember the great time you had in the 187th, and you're going to be like, yes, she still gives to us. So you're always welcome to the 187th. It's open to the public. A lot of the courtrooms are open to the public. I just discourage people from going to children's court and juvenile court because those involve juveniles. But anytime you come to this section of the building, these are adult courts. So you're more than welcome to always come to the 187th District Court. I'm going to call the persons who are going to be on this panel. And when I call your name, I'm going to ask that you take a seat in the box. Angie Hernandez. Bonnie Giddens. Helen Cutlip. Elizabeth Lucas. Husker Delostrinos. Michaela Mason. Benjamin Higginbotham. Isaiah Cruz. Kathleen Harrington. Michelle Junko or Junko. Sharon Bennett. April Stokes. Irma Castillo. Henry Austin. All right, ladies and gentlemen, to the rest of you, the deputy is going to show you which way to leave the building. Because it's after hours, you'll be leaving from a different entrance. If you have any questions about where you're parked, because I know sometimes people get turned around, if you'll ask the deputy will let you know. And again, juror number 29, Michael Garcia, you're going to have to report for jury duty tomorrow in the basement. Do you understand? All right, thank you. All right, thank you all.
Yeah, we got it.
They're not gonna be.
Yeah, we got it.
Yeah.
All right, everyone, please be seated. I'm going to give you all some instructions, and then after that, I'm going to let Deputy Laura take you where you need to be. All right, so tomorrow, we're going to be here all day. And when I say all day, I try to have us break at 4:30. That way everybody can avoid rush hour traffic. But again, I like to be fair to both sides. So normally if we're in the middle of a witness's testimony and we're beyond 4:30, I still let us continue so that both sides, if they wish, can have a chance to question that witness. This courtroom, the temperature sometimes fluctuates. It's usually, well, it used to be super, super hot in here. So now sometimes people complain about the cold, but we would rather have the cold than the heat, because there was a time when it felt like 90 degrees in here. So if it is better for you to bring a jacket or something, I always say it's better to have it and not need it than to need and not have it, because we do not have any extra jackets for anyone. The other thing, I know those chairs are hard. I've been working on trying to get some improvement with that, but it takes a long time when you're dealing with the government. So we have slowly been buying cushions. So in the back, there are cushions. You're more than welcome to bring them out and use them. Or if you have a cushion from home you want to bring, you can bring. And throughout this jury trial, if you bring your cushion from home and you leave it here, it will be protected because it will be locked in the jury room. The other thing, drinks. You are allowed to bring drinks into the courtroom. Just make sure there's a cap on it, so if it drops, it won't spill. The other thing is you will not report tomorrow to this specific courtroom. You're going to report to the jury room, and Deputy Laura will show you where that jury room is. We're going to start tomorrow at 9:45 because I have a docket that I need to take care in the morning, but that should occur very swiftly. So if you all can make sure you're here at 9:45. Here's the thing. Tomorrow is Wednesday. We have jurors that report to courts all week except for Friday. So there's usually about 200 jurors, and we only have one parking garage. Again, the government built that. So they didn't take in consideration the number of jurors plus all the employees who are here. So in order to be assured that you will have a chance at a parking space, even though I say 9:45, it's probably best that you're here by like 8:30, so you'll have a space. There is a refrigerator, and is there a microwave or something in the back? That is all that in the jury room. You're more than welcome to use that. You're more than welcome to bring food. If you want to bring your lunch, you can bring lunch, put it in the refrigerator. It will be fine. I don't expect any publicity to be involved in this case, but if something occurs on television, any type of social media, you are to disregard it. You are to base your decision, if you have a decision in this case, from what happens inside this courtroom. Do not go out, try to do your own investigation. Do not go out Googling or looking for names of parties who may or may not be involved. Everything you need to know about this case is to come from inside the courtroom. Does everyone understand? All right. So are there any questions? Yes.
I need to make arrangements. I can move them.
Okay. And when are your appointments?
Well, they're tomorrow, but I can move them. I've already talked to them, so kind of like move them next week. Is there like a?
I would say put them for next week. I would say next week, midweek. I say that. Here's the thing. A lot of people think as a judge that I've heard evidence in this case. I have not. Usually after the state gives their opening statements, and if the defense chooses to give an opening statement and I hear the first witness, I usually have some idea based upon my experience how long a trial may go. So I will be better able to tell you that tomorrow. But I would say just on the safe side, definitely move those appointments from tomorrow. I would say you can set it for maybe Wednesday, but I will definitely know by tomorrow where we are on this trial. All right, any other questions? Yes. Yes, and what will end up happening too, if there's an issue with your employers, you can always give them the court number and the clerk will let them know that you're here in jury trial. Any other questions? All right, the other thing before I send you back, whenever we're in court, if anybody needs a break, just do the break symbol. If I don't see it, they will see it, or they will see it, or the deputy will see it. So just let us know. Yes. The thing about notes, I don't encourage people to take notes. And this is, let me explain to you why. Because you are not allowed to use your notes during deliberation. The person who's in charge of the official record and what has happened and what people have said is the court reporter. And it's just easier if everybody's actively listening to what's being said and looking at people and hearing what they say. Is there anything else? All right, so we're going to start tomorrow at 9:45. We cannot start at 9:45 if everybody's not here at 9:45. So if there's one person missing, we're going to have to wait for that person. All right, and Deputy Laura will show you where you go. Remember, do not report to this courtroom. All right, everyone, please rise.